Abundantly, it's what he promised me. I live accordingly. Faith and favor's a blessing when you believe Christ has a plan in motion. Just trust him, yeah, it's a guarantee. Philippians 4:13, I can do all things through Christ who strengthens me.
Everything husky.
Good morning, it's another day, my friend. But soon the sunshine turns to moonlight, life goes It takes some time to say goodnight. You close your eyes to dream next thing. Tomorrow's here.
It's a brand new day. Never hold on to hate, cause you was placed here to be great. Please take your place. All queens got a seat at my table, cause without y'all, then the man ain't able. Melanated queen, connected to the universe, and so I gotta thank my mom for my birth. If hate is the curse, then love is the remedy. So I send you love no matter creed or identity. Until infinity, look at you like you kin to me. Even when we disagree, yo, you still kin to me. In other words, I can't bring you no trouble, can't bring you no beef, don't wanna see you deceased. Now if I'm coming at you, I'm coming with a business plan, cause every day I'm on some, yo, let's get this money, man. Yeah, and that's my real plans. I rest my head at night, I wake up, I got another plan.
Good morning, it's another day, my friend. But soon the sunshine turns to moonlight, life goes It takes some time to say goodnight. You close your eyes to dream next thing. Tomorrow's here again.
It's a lot of high rappers tell me why we don't get money together, but we'll kill each other over whatever. Running down the freeway, we gonna own down. If Black Lives Matter, why we gonna own down? That's why they laugh and they think that we clowns. They hear what we say, but see how we get down. We gotta change that now, right now to be exact. Cause hurting that man's moms is not where it's at now. Old school, new school, need to learn, yo. They put us in groups so they can make more dough. The young versus the old versus the young. Black versus white, you see the pattern, right? No unity, keep them all on some gutter-ish. This way they don't prosper and get rich. Yo, can't you see it's a trick? Just open your third eye and you'll see the full view of it. Now yo, what if the powers that be know that the real power lies within the people? That's us. And what if they using things like crayon colors, black and white, to separate the people? Hey, yo, you gotta wake up. Don't let them fool y'all. Spread love.
Good morning, it's another day, my friend. But soon the sunshine turns to moonlight, life goes It takes some time to say goodnight. You close your eyes to dream next thing. Tomorrow's Good morning, it's another day, my friend. But soon the sunshine turns to moonlight, life goes It takes some time to say goodnight. You close your eyes to dream next thing. Tomorrow's here again. Good morning, good morning, good morning, good morning. Good morning, good morning, good morning, good morning.
All right, y'all know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. Oh man. Woo! We're doing it, y'all. Shout out to everybody who's in the building. It's good to see y'all in here. If y'all couldn't tell, we're running a little bit behind this morning. We are on Pacific Coast time today. Oh my gosh. Let me make sure we're good. Shout out to everybody who's in here. I gotta turn this volume up a little bit. All right, y'all are saying we're good. I think we should be good. We should be good to go. Oh my gosh. I've been in here running this morning. Good to see everybody in here though. I think we should be okay. I see y'all in here. I see y'all in here. Okay, shout out to everybody who's in the building. We're gonna go ahead and get into it. Let me double check and make sure we're good. There we go. Yeah, I need to fix my, hold on a second. Let me fix it in the screen. There we go. Welcome y'all. Welcome back to another YouTube live stream and another episode of the Music Morning Show. I'm your host, ClassE Beats, ClassEbeats.com. And today we've got a lot we got to go over. Some things went down yesterday afternoon, yesterday morning that we didn't get to cover when it comes to the YSL trial. I had some other stories lined up today, but then as I started going through everything this morning, I realized there was a lot that happened yesterday. So we're going to go through it. I'm going to give y'all some updates on what's going on in the trial, some of the new motions that were filed, some things that got denied. And we got to talk about our new favorite judge, Judge Whitaker. I think she might be switching up on us, y'all. I think she might be switching up. I was a little disappointed at some of the things I heard over the past couple days, but we'll go ahead and get into it here in a second. But first, let me say what's up to everybody who's in the building, man. Shout out to y'all. We've got DTB is up in here, says top of the morning. There's a smoothie for me. I appreciate you. It's a little bit later in the day, so I already got my smoothie in here. Out of orders in the building as well. We've got Kirsty. Oh, Kirsty, I messed up your name the other day. I said Christy. We've got Kirsty Ann is up in here. Kay Cooper is in the building. Good to see you. Blackjack is up in here. We got Floyd, the real deal, Neil in the building. Let me give y'all a round of applause. Let me make sure the volume's good too. Is the volume good for y'all? We should be good. Let me double check this right quick. Should be good on the volume. We got Lauren Robinson in here. We've got Jana's in the building. She says, hey guys. Shout out to, oh man, a hawk killed your rooster. Dang, I'm sorry to hear that. I hate when that happens. My mother had a bunch of chickens and it seems like the roosters are always the ones that go first. And they got wiped out within a couple of weeks. Them things was gone. Sorry to hear that, Bill. Sorry for your loss. I know that's a big deal, losing a rooster. You don't want to see that. Mixed Chick Samantha is up in here. Good to see her. Who else? Mr. Tesla said, Mr. 40K, what's good? We about to hit 41K today. I'm calling it. We're going to hit 41,000 today. We got John Johnson is up in here. Says, good afternoon, good morning if you're on the West Coast. We got Noobs is up in here. Shout out to Noobs. What is Noobs saying? Anybody else think that from Glanville's perspective, that a not guilty verdict is in his best interest at this point? Why do you think that would be Glanville's best interest? Is it because if there's a mistrial, then it's going to reflect poorly on him in the way he handled this case? If that's what you mean, then yes, I would probably agree. If this goes the whole way, and then the jury decides, hey, y'all messed it up, we're not going to be able to give a guilty verdict in this, and then Glanville can say, well, you heard what Judge Krause said. She said I was doing my job, but y'all just didn't like it. Y'all didn't want to see me go on through this case because I'm a successful black man here in Atlanta, and y'all were just hating on me and we're trying to bring the black man down. But hey, I did my job. Judge Whitaker did her job. Not guilty. Let's move on. Let's go play some golf. I get what you're saying, Noobs. That could possibly be the case. Either way, Judge Glanville, he got recused. That's never a good look when it comes to a judge. But we know Judge Krause tried to throw him a bone, so we'll see. King Creole is up in here. Shout out to King Creole. We got Boss in the building. What's up, man? Urban Mainstream is in here. Says good morning. We got everybody in the building. We've got Twerk is up in here as well. My Journey, My Experience is dropping ones in there. We got Jason in the building. Smoking the One says, yeah. Good to see you. We've got the amazing Amy up in here. Good to see Amy. Shout out to Amy in the building with the new profile pic. She also reminds y'all to like the video. We've all got 1,000 people up in here, and 10% of you have already liked the video. So if we could get it up to 50% likes, I would appreciate it. And shout out to Amy for reminding y'all that. I'm gonna put that up there later. Boss says ClassE and Amy finally decided to show up. We in here. Don't concern yourself with what goes on behind the scenes. We got Johnny in the building as well. Who else is in here? I know I missed some of y'all. I want to make sure I shout out everybody. There she is. We got Jenny D in the building. We've got Brooke Smith up in here. Tammy says good morning. Blackjack shouting out from the UK. Still prayers go out to everybody who's dealing with Debbie. I know a lot of people close to me and a lot of my friends are dealing with it too. So y'all be safe out there. Smokey said, man's almost halfway to 100K. Unreal. Hey, we putting in the work every single day, man. So nobody's surprised, but we definitely are thankful. I appreciate it. We've got Tabasha. Is that right? We've got Miss Hunter up in here. I want to put some respect on your name. Appreciate you. Satin's up in there as well. Shout out to Satin. And Noob says, no worries about appeals court. We'll see. It's crazy out here. Absolutely crazy. It's on both sides for Glanville. Said, yeah, y'all are ready to get into the content. Terry is up in here as well. We got Brooke in the building too. Shout out to Brooke. Says, good morning from Vegas. Shout out to Vegas up in here. Smoking the one said Clout E beats. Oh man. Amy says, sorry we kept you guys waiting. Amy. Lauren says, free Jeff, Metro Boom. Yeah, are y'all ready to get into it? I know I usually like to do a couple of announcements today, but I know y'all are dying to get into our topic, which as you can see in the title, it's looking like Judge Whitaker is saying there's a possibility of a mistrial. This is absolutely insane and crazy. Let me say what's up to a couple more people. We've got Monty and the Murphys in the building. Says, love your coverage. Thank you for watching. I appreciate it. We've got Angie says, I'm an orphan from Catch. Now, Angie Lee. Now, I have to say this. I have not known Kat for that long, but from what I do know of Kat, she would never abandon one of her chat children. So I'm gonna have to let her know that you feel like you're an orphan out there. Shout out to Kat, not William. She was live streaming this morning. I was over there checking her out. Y'all go show him some love. She has some great content over there too. She wouldn't abandon you. I'm not buying it, Angie. I appreciate you being here though. K Cooper saying her good mornings. We got Sexy Chocolate back in here. Says, hey, from LBC Cali. I love your input on this trial. Thank you. So it's still morning over there where Sexy Chocolate is. I appreciate you. All right, if y'all are ready, we're going to go ahead and get into it. Cash Rules says, what's good from Richmond, Virginia? Hopefully you're doing well out there, Cash Rules. I know y'all are probably getting some of that nasty weather that's been going on from Hurricane Debbie. So y'all be safe out there, and hopefully you guys are doing well too. Amy's reminding y'all to like the video. We've got my guy, Ulster Man, is back in here too. Good to see you. Says, you my guy, Miss Love, a high visibility and a deer stalker today. No, there's no court today. If y'all are here for court, there is no court today. We're not going to be back until Monday live with the live streams from court because Judge Whitaker is taking some time off, giving everybody a chance to get ready for Monday. A lot of things are going to happen on Monday. So y'all make sure, if you haven't yet subscribed to the channel, hit the notification bell, because come Monday, there's going to be a lot of things that are going down. The first thing that's going to happen on Monday is the attorneys have to get there. So they got to get there. They have to make sure everything is ready. They have to make sure they have everything set and are ready to tell the jury their instructions on what's going to be done, what they're going to say, and what they need to remember and not remember. We're actually going to get into that in a second. We're kind of jumping ahead. But anyway, after that, the jury will come in. They'll talk to the jury. Then shortly after that, we're going to have our guy, Lil Woody, back on the stand. So Woody is going to be back on the stand, and he's going to decide if he's going to testify. We have no idea what he's going to do. Y'all can tell me in the chat if you have an idea of what you think Woody's going to do, what you would do. if you were in his position. I don't know. Everything's all up in the air. So Monday is definitely going to be crazy, especially right off the bat. So we'll have to wait and see what happens. We've got, did I see Wealthy Wisdom in here? Shout out to Wealthy Wisdom in the building saying good morning. And I think I got everybody. We've got Mr. Brown is up in here too. Shout out to Mr. Brown. Steve Holland is in here. He said volume is kind of low, brother. Is it? Okay, how about now? Is that better? I noticed that on one of my other videos too, that my volume was low. That should be good. K Cooper is saying he better plead the fifth. Okay, so I'm gonna put the poll back up in the chat then. Okay, it is better. Perfect. Thank you, Steve. I appreciate that. We're gonna put the poll in the chat. Will Woody testify on Monday? Y'all let me know what you think. We got over 1,000 of y'all in here. Let's go ahead and get into it. Hollywood Co said Mistrial Monday, speaking it into existence. We're going to talk about it here in a second. But first, we got a couple of super chats in here. Y'all give it up to Amy with the 2-bomb over there. And the new profile picture. Oh my goodness. Appreciate all the super chats. I will be reading super chats throughout the show too. I do not require y'all to send super chats, but they are appreciated and they do help the show continue to grow. So thank y'all for all of the support that you give through super chats. So let's go ahead and get into our next topic, or our first topic, I should say, if y'all are ready. This one is going to be interesting. So we went over and reviewed this whole situation about the jury coming back on Monday. Then it looked like Mr. Bruce Harvey was tasked with coming up with instructions for the jury. So what were his instructions for the jury? We read through them. I want to read through them again, just so y'all can kind of hear some of the issues that are in these proposed limiting jury instructions that he has. And then once we read that, we're going to go ahead and actually look into a video from the court proceedings where Judge Whitaker made some interesting statements about the jury coming back this Monday. All right, so check this out. This is the state of Georgia versus Mr. Nichols, aka Mr. Bruce Harvey, and this is the proposed limiting jury instructions. Now, if y'all bear with me for a second, because the way this is written, it's a little tough to hear. So, what does he say? I instruct you that some evidence may be admissible as to some of the counts or some of the defendants, but not admissible as to other counts or other defendants. Here it's starting already. In that regard, evidence related to certain alleged acts specified in count 1 of the indictment may be admissible against those defendants on trial charged in the court. However, I remind you that in order for you to use such evidence against those defendants not alleged to be involved in the court under your consideration, you must consider whether the alleged acts or which the evidence is being offered have been proven beyond a reasonable doubt to be part of the overall scheme alleged in count 1. Oh my gosh. Yeah, this is crazy. Likewise, evidence of a person's prior statements that may be different from those admitted here at trial may be used by you to elevate the credibility of a witness testifying, but not as proof of the matters asserted or against others not alleged to have been involved in the events being testified about. That is, prior inconsistent statements are offered for the limited purpose of determining the credibility of the testifying witness and not to prove the truth about the truth of the statements made. Okay. And that's by Mr. Bruce Harvey. Saying all that to say, basically, we need to be careful with the kind of information that we give to the jury. Whew, that was rough. I'm with y'all on that one. So if we skip ahead and go forward to when court came back in session yesterday after lunch, Judge Whitaker realized that she saw these limited instructions requests from Mr. Harvey, and she addressed them. And she also makes some interesting statements about the jury and what possibly could happen this coming Monday. But y'all check this out. Make sure the volume's good too.
The suggested instructions sent by the state dealt with Right. Mr. Copeland, how to handle Mr. Copeland's thing.
Yes, I have a response with respect to Mr. Harvey's request. but
Okay,
not
if you
a-
want to email that to Ms. Percefield.
It's not a suggested response, suggested instruction. It
Right.
is a response that we should not give an instruction and the reasons why at this point.
Regardless, I haven't seen it, so if you want me to.
I was gonna orally, but I can.
Okay, that's fine. If it's not in writing, that's fine. I thought you were, I maybe misunderstood you. I thought you were saying you had sent something over. But no, if you just want to orally say, here's why I don't like Mr. Harvey's instruction and why we shouldn't give one, that's fine. I think if we do give it, we need to work on it. And I'd also like to maybe sort out from Mr. Harvey. I'm trying to find it. There it is.
What's up, Belgian?
So there's the kind of limiting concept about RICO versus other counts, but then there's also included in the same instruction, hey, here's how you might consider prior statements. And are you just proposing that I give some general instruction like this at one point and then we move on? Or
So
I'm
she's
not sure
confused
what you're
too.
proposing.
She's like, what are you talking about, Mr. Harvey?
When, for example, we have Mr. Copeland on the witness stand, we've spent an inordinate amount of time going through his prior statements.
Right.
We're using the
to
big
weed out
words.
those portions that may or may not be admissible. But the point of the prior statements is that he is being impeached
Right.
from his testimony at trial. And if it is impeachment evidence, then it can be considered with regard to the credibility of Mr. Copeland and for the act in question, but not for any other purpose. That is, I guess, my point. And you know, we just got a potential witness list with exhibit descriptions, which includes the captions impeachment in some of the categories and some of the exhibits.
Mm-hmm.
And I know those are potential depending upon what the witness testifies about, but we're clearly in impeachment territory with Mr. Copeland. So I understood your
If he
honor
testifies.
to say, look, this may be admissible against everybody because they're all charged in count one. And that was the first part of my proposed instruction. That's what I understood you to say yesterday. And I don't really have an argument.
You know what? Thanks for bringing that to my attention because you're right. I guess, yes, during this exercise,
Yes.
I guess at some points I've been thinking about, okay, substantively speaking, how does this come in? And you're right. If we're thinking about certain of these things as coming in only if they are prior inconsistent statements, then yes, you're absolutely right. So yes, thank you.
Well, that's why it was
Okay.
joined together.
Okay. So I guess thank you for that clarification. And then also what I'm asking is, are you suggesting that I just give this general instruction to the jury, you know, basically whenever we restart the trial on Monday? Or are you saying before each kind of thing comes in,
Well, I
I
don't necessarily know whether you need to do it beforehand. And that was the old rule prior to the new evidence code. And I think the old cases, and they were old cases from like 1990.
Can you try to speak into your mic?
Oh, I'm sorry.
I know it's a lot to do at once.
The old cases were from like 1998, and they said you got to give it beforehand. And you said that yesterday. Boy, I think you got to give it beforehand. And I don't think that's the rule anymore. And I think if you look at the new proposed jury instructions for the Superior Court jury instructions,
Yeah.
it says, and I'll quote, note, new code section requires the judge to give limiting instructions when applicable on request. Probably better to give, if applicable, whether requested or not. Now, if witnesses are not impeached by prior inconsistent statements, then it's unnecessary to give it. If they're impeached after and there's a prior inconsistent statement that may be admissible, I think after that evidence comes in, not before, because you won't know necessarily.
Sure.
You can say, this is admitted as impeachment, and it goes to the credibility of this particular witness. That's my request.
And I got to take a second and give a shout out to Japan SPR 94. What do they say? I got to go back and read some of these comments because these are important. Anytime a lawyer or a legal professional stops by the chat, we got to take a break for a second. So they say, I'm a litigator in Atlanta tuning into your channel. I pass the courtroom often, but stay clear of the YSL and Trump circuses in court. Yeah, absolutely. That's putting it lightly, I'm sure. What does Japan also says? Prior inconsistent statements, impeachment go to the credibility of the witness, which is hilarious. And we've mentioned this before, that the state is wanting to impeach their own key witness. Woody is just out of hand. It's crazy at this point. They say, I'm a lawyer in Atlanta, and from what I've seen, there will be a mistrial. I didn't expect this, but here we are. Wow. Also, I've more about this case. I've more, maybe I've learned more. I'm not sure. I've learned more about this case watching you. I avoided in the courthouse. I appreciate it. Thank you for being here, Japan. It says, I also just won a criminal jury trial against the DA's office earlier this year. Hey, Japan, I'm right here in Fulton County too. If you need somebody to watch your back, I got you. But just hold on for a few more months. Once Trump gets in office, we're going to take care of Fanny. All right. I made the phone call. We got you. You're good. Thank you so much for stopping by, Japan, though. If you want to call in, if you can call in and share your thoughts, the link to call in is in the description. I would love to hear your thoughts on everything that's just going on with this, with Fulton County, Fannie Willis, Miss Love. You wouldn't have to give any like inside information, whatever you feel comfortable sharing. If you want to call in, the link to call in is in the description and in the pinned comment in the chat as well. Thank you for being here. I appreciate it. All right, let's keep it moving, y'all. Let's see what Mr. Harvey's talking about.
Okay, so
That's why it's in two phases.
Well, yeah,
Or two paragraphs.
Yeah, as you proposed it, that's kind of what I'm trying to sort out is they are two different topics. Do you want it as just one big instruction and no, I don't think that it's appropriate every time a witness is impeached to say, hey, this might be impeachment, or this is or was impeachment, and here's how you consider it.
Well, it may
and not talking necessarily to kind of impeachment evidence, but sometimes there's other evidence that comes in for a limited purpose.
I agree. And I have asked for instructions when I thought, and the state has objected, and they've said, look, it comes in against everybody, and I understand their argument, and I could probably give the same argument that I know Ms. Love is going to stand up and give.
Yeah.
But I have asked for those instructions. And when evidence comes in as impeachment, I'm going to ask for the instruction and have it limited to that particular count and that particular person.
Your Honor, I would.
Yeah.
Just Whitaker said.
Just as
What are you talking about, Harvey?
Mr. Harvey's words regarding evidence that comes in as impeachment. I'm hearing, and I'm aware that he may not be saying it as I interpret it, but this makes the second time once he previously, before Your Honor began presiding over this case, once he expressly said impeachment evidence cannot be used as or is not substantive evidence. And I wanted to just make clear that under our evidence rules, impeachment evidence is in fact in the form of a prior inconsistent statement. A prior inconsistent statement is substantive evidence, not just impeachment evidence. So to the extent that Mr. Harvey is asking for any kind of limiting instruction.
Y'all set him up. Just admit it.
We ask or we admit a prior inconsistent statement that is impeachment evidence. I would object to that because that statement now becomes substantive evidence that is admissible, not just for one person.
Again, Ms. Love?
Or to, somehow attack the credibility of the witness on the stand, but now it becomes substantive evidence of what is stated, of what is given in that prior inconsistent statement. And because each of the counts in this indictment are alleged as overt acts to
Oh my God.
Have you ever had a dream that you could do so you
Come on, man. Again? I thought Harvey was bad. I mean, at least he's using the big words. Good Lord. And now she's pausing. What are you trying to say, sister?
indictment
Somebody
are
help her
alleged
out.
as overt acts to overt acts in count one, and everyone is charged in count one. A limiting instruction based on
What's up, Gabby?
Mr. Harvey's interpretation or assertions regarding inconsistent statements and the acts alleged regarding or who is alleged to have physically committed the acts would not be proper. The response that I have to the
This trial is a mess. I know Judge Whitaker is up there dying. First, she's having to go through this mess from Mr. Harvey. And shout out to Joseph Pat for posting this. What did Mr. Harvey say? Look into this. What was it? The second sentence? In that regard, evidence related to certain alleged acts specified in count one of the indictment may be admissible against those defendants on trial charged with that count. However, I remind you that in order to use such evidence against those defendants not alleged to be involved in the court under, like, what is going on here? And then we've got Miss Love buffering live in 4K. This is amazing.
Requested instruction he has sort of it makes it it goes into it a little bit more.
Oh my
why it would
gosh.
not be proper, but just based on what he has just said, we would object to that primarily because an inconsistent statement is substantive evidence.
All right. Well, with regard to the beginning of your paragraph one that doesn't concern prior statements, that I think is meant to concern the RICO count, that needs to be much more specific. So maybe if you could endeavor to make it more specific as to, I mean, if I'm going to give the jury an instruction, I want them to actually benefit from it. So, you know, let's talk specifically as to RICO, and then I guess I am asking, prior statements aside, as to the RICO issue and then the substantive counts issue, is your proposal that I say this once, hey, these people are charged all in count one, which is RICO. Certain people are charged in other counts, other people are charged in different ones, and we can be specific about it. But
yeah, shout out to just Whitaker for interpreting.
Keep in mind that it can all be considered against everybody with regard to your determination of whether the state's made its case on count one. But
yeah, and again, this is going to be so difficult for the jury to understand. I know a lot of y'all, we've got a very, very, very high level IQ community here, and y'all know, and we've read through legal documents and kind of understand where she's going, but you're going to have to frame this in a certain way to where it just doesn't go over the jury's head. I don't know. I don't know what you're asking me to do here. So you're saying I need to understand count one applies to everyone, but there's certain parts of count one that only apply to certain people, but still those certain, it's a whole mess. It's a mess.
It can only be considered as against the defendants who are charged as to everything else.
All right.
And give that once, or give that, I mean, I think give that once, because otherwise it's, you know, okay, now I don't know if we're going to very cleanly break each time from, all right, this is counts 2, 3, and 4. Now we're done with that. This is counts 5, 6, and 7, you know, so that I could separately charge each time.
But the jury has to make the determinations as to the predicate counts. Did the state prove that first place?
I know
this predicate count. Did they prove this predicate count, and that
Suddenly.
anybody else may be a participant or should be? That conduct should be imputed to anybody else. That's the issue.
That's the whole concept of a conspiracy in RICO.
I get it. But when you are admitting inconsistent statements.
All right, now, I don't want to talk about inconsistent statements right now. I'm talking about how to handle the RICO count and what should be limited with regard to that. Okay, we'll get to the inconsistent statements in a minute.
We will try to make it more specific and resubmit it. If that's what I understand.
All right. Yes.
Yes, please do.
And then
We're trying to get
do
there.
you all think that and I know you don't want one at all from the state on how they should consider other charged crimes against everybody as for RICO, but not against everybody as for guilt to that crime itself. But assuming I'm going to give one anyway, is the best way to do it a one-time, let me explain this to you, and
That seems to be the best way to go about it, honestly.
how you consider it, and not every time we move to.
Uh-oh, come on now. We should have been good on this one. Y'all bear with me for a second. I'm trying
Let me
to
explain this to you and
There
how
we go.
you consider it, and not every time we move to a potential different crime. I'm leaning that way, so I'd like for y'all
Here we
to
go.
try to craft something that way. So anything else on that?
Just to say that broadly, to give an instruction at any juncture other than the end as it relates to the RICO count and how it should be considered would be confusing and premature, because it would be incomplete. Especially the way that we've seen it in Mr. Harvey's proposed instruction. So just as much as the court is asking, how are we proposing instructions be given on, during or throughout or at one time at the end. Our position is that regarding this topic, at the end, at the very least, one time at the end, and we have more to say that we can put in writing in response to Mr. Harvey's.
Okay. Well, I don't think it's particularly helpful to have the jury not have any idea how they are supposed to be considering and evaluating this evidence while they're listening to it. And I know they're not deliberating on the evidence until they all get together at the end of the case. And I know that they are not making any kind of determinations about it until they're deliberating together at the end of this case. But as they're taking it in, it might be helpful to have them know how to be conceptualizing it. And if this were my trial from the outset, yeah, it would be pretty bizarre for me halfway in to be like, oh, hey, by the way, here's an instruction about it. I would have done it before now. But if I'm going to do it, it's not that weird for the first time they see me while I'm telling them other things anyway.
Yeah, this is a struggle.
And hey, this might be helpful as well. Here's something that you need to think about, and here's a way to think about it. So,
wow. And while we got a second, let me give a shout out to Amy in the building, man. Gifted 10 memberships. If you got a membership from Amy, make sure that you say thank you. Also, shout out to Mar for dropping the 99-cent bomb. I appreciate you over there, man. Listen, super chats are not required, but they are appreciated. So I appreciate y'all, and especially appreciate Amy, as Lauren said in the chat, the biggest supporter of this channel and one of the pillars of this community. So thank you, Amy. Here we go.
what I mean for that is, and I mean, I think I'm making the decision anyway. I think the appropriate way to do that is to give that instruction once and then give it again at the end to remind them, but not throughout the entirety of the trial each time we move from one set of crimes to another.
Mm-hmm. We got to get out of this buffer zone.
I'm going to let Mr. Atkins address part of what the state's response is. And then if the court will permit me, I just have to say a little bit more after he addresses the first part. Go ahead.
Your Honor, I just wanted to highlight that I think an important thing to consider, because there seems to be conflating the concept of relevant evidence and admissibility at trial with every defendant being charged in count 1, the RICO. Evidence of, for example, Act 39 we talked about, Mr. Winfrey. If the jury finds that overt act was made by Mr. Winfrey, that is relevant evidence to their overall determination. And so I think any instruction, if the court were to give one, I think, as the court alluded to, it needs to illuminate something in the jurors' minds, not confuse them, but explain something. With every defendant having count 1.
Yeah, good luck with that.
There's no defendant who's not charged with that. So all of the overt acts which track the indicted counts, if someone is not mentioned in evidence presented in Act 39 and defendant X is never mentioned, the jury never hears any evidence of that specific defendant, that evidence is still relevant when they're deciding count 1 for that defendant who was never mentioned in said act. And so and of course,
to Amy,
trials of this nature, the jury instructions, they take a lot of heavy lifting legally in thought. And the case law.
Okay, while we got our guy rambling here, there's one thing I wanted to point out. And this is my thought with the jury. So they're going to be instructed. I can talk. The jury's going to be instructed at some point to forget everything that was said from June 12th to June 14th, right? And one of the things that we're going to have to look at is, okay, are they going to be able to forget Lil Woody's testimony? As we've talked about before, how many jurors are going to say, yeah, I can forget that, I don't remember it. But just look at, and I want to pull this up, just look at Lil Woody's testimony. What did Lil Woody actually say? Now, we got some great sound bites. We've got some great memes from Woody, but if you listen to what he said on the stand, he really didn't say that much, in my opinion. So honestly, if you're asking the jury, hey, you think you guys can forget everything that was said by Lil Woody, it might not be that difficult for them to do. It might not be that difficult of a task. I'm trying to find, I want to skip through here until Woody is on the stand and see if I could find one of these videos. Hold on. So these are, again, these are the interviews. So they're allowed to see that. And there wasn't even any questioning on this day, but we'll get back to that in a second.
Makes that clear that what instructions the jury are given.
Court resumes on Monday.
To be clear and concise, because it's naturally with so much evidence it's important to get those instructions right. And so I think that is just an important thing to keep in mind of relevancy versus admissibility. And some of things in regards to relevancy, if they're admitted by this honorable court, any argument can be made at closing of why it is not tethered to their client or why the state didn't prove count one. And I just wanted to share that because I think it's important when thinking through this. And to ensure as well, given the endeavor of jury instructions at the end of trial, that whatever we instruct the jury now, we don't want to instruct them something different later after a more fleshing out of all of the jury instructions. Because, of course, jury instruction as a whole are what's considered from appellate courts in terms of if one specific instruction was proper or improper. And so I just wanted to highlight that for the court while we're thinking through this.
Okay.
And Your Honor, I just wanted to tag on to that, that I heard Mr. Harvey reference predicate acts, and I wanted to just emphasize how overt acts are not necessarily predicate acts, and we don't have to have any predicate acts in this case. And Mr. Harvey's instruction that he's given the court so far is just wrong in that it implies that evidence introduced under count one is not something that can be introduced against every defendant, just to follow up on the admissibility or relevance distinction Mr. Atkins just made.
Yeah, okay. Wealthy Wisdom, I get what you're saying. Wealthy Wisdom says they might use that opportunity to say it can't be unheard so they can get out of the case. But what can't be unheard? Now, if we've been sitting here, we've been reviewing this case, dropping 3 videos every single day, covering this live, going through Woody's testimony. And you've got to remember the jury only heard him for a couple days. I mean, we've been reviewing this content over and over and over and over, and we can't really think of something that we could say, oh, but remember, Woody said that. I'm not going to be able to forget he said that. All we can remember is she fine. I don't recall. What you mean? Oh, get back. So I get what you're saying, and I see that. But again, me just looking at it, not as an attorney, but just as a regular person who could be a juror in this trial. I don't want to get paid $25 a day to sit here, but if you're going to be honest and you're sworn in and you got to admit there's not really much to remember from Woody. So that's just my thoughts anyway. I could be wrong.
The other
we'll see on Monday
point that I wanted to make is that understanding the court's inquiry and concern about instructing the jury and making it clear for them how they are to consider evidence as we go along. My question regarding the instruction that Mr. Harvey has proposed is, what problem exists right now that we are trying to solve with the instruction? And my answer to my own question is that there is not one at this time prior to the close of the evidence that requires us to give the type of limiting instruction that Mr. Harvey is requesting. Right now, as it reads, his instruction is misleading and it's confusing.
Well, yeah, it is not particularly helpful at this point in time. It's a start because he at least sent something. So, which is what I've been asking everybody to do for the last week and a half.
The audio's low. I got
But
you.
yeah, no, it's not what we're going to use. It is not particularly elucidating, but it is at least something. So thank you for that, at least.
May I respond? I'm sorry. I didn't know whether you're done or not.
I was just going to point out that his instruction, it sort of implies something, but that proof of a substantive RICO violation is not an element of the conspiracy violation that we've alleged in our indictment.
Well, and I mean, in all honesty, nothing about this even mentions RICO, which is what we're trying to clear up for them. So it needs to be much more specific and targeted also. I mean, this is just general amorphous,
Well,
not helpful.
that, you know,
Sorry.
I understand, and it's very hard to pinpoint. I think it's extremely difficult, and in that sense, please don't quote me. I agree with the state. First time in my life, perhaps.
Yeah, probably so.
But I think what the state is doing is conflating the gang charges, because if these go to the gang charges as well, then I want you to instruct the jury every time gang evidence comes in that the mere participation in illegal activity with a gang member or gang members does not, as a matter of law, constitute gang activity.
Right. It's got to be in furtherance of the gang. And I will give an instruction to that. It will not be every time gang evidence comes in. That'll be an end of the case instruction.
But that's what's being conflated here. We're getting RICO evidence, we're getting gang evidence, and it's coming from the same witness. And that makes it very difficult to parse out, given that kind of...
That's why we're going to have really good instructions.
And Your Honor,
I agree.
The gang is the enterprise that is charged.
I understand. So let's get something much more specific than this.
Yes, let's do that.
Now, on the prior statements thing, sometimes they're only impeachment and sometimes they're substantive evidence. So it's not true that every time a prior inconsistent statement comes in, its only way that it can be considered is as to the credibility of that witness. It's not true.
I concede a split in authority. The 11th Circuit specifically says that impeachment evidence, inconsistent statements are...
Are they talking about Georgia evidence or are they talking about their own? So then it doesn't matter what federal courts say about it.
But it's the same rule. It's the same rule, and I get it. I conceded that. I'm conceding. I'm arguing. It's the same rule. It is the exact same rule. The Georgia courts have specifically said we're adopting the 11th Circuit. So I think there's some disagreement, but I concede the Georgia rule. But sometimes it's still just impeachment.
Sometimes.
So, and, the state has said several times, both in their in their exhibit description. And today, when arguing to Your Honor, that's impeachment evidence. If
I got
we
you,
may
Floyd.
just want to impeach them with that. And that would go to the credibility as to that act. And Mr. Nichols is not charged in that act. So I think, and again, I agree, it's very complex and it's hard to parse it out. And I think it's difficult for us in the court. I know it's difficult for the jurors.
All right. So with regard to prior statements, it's kind of whether we're talking about a witness who's testifying or it coming in some other way. But when you're impeaching a witness who's testifying with prior inconsistent statements, it's substantive evidence when it comes in. So, all right. Now there's the other issue of the jury instruction I am going to give. Oh, and obviously one jury instruction I'm going to give, we had discussed before, and it's, and I had read it out, but upon further consideration of some of the motions that have been filed since that time, including the kind of new spin on Mr. Stilwell's motion for a constitutional and fair trial with requested relief, and just considering some of the motions that have been filed, I think, by Mr. Williams since, I am actually reconsidering and have reconsidered and made a different decision about, at one point I had said I was going to just say disregard any comment about any of the actions of the lawyers. And I'm going back to the proposed instruction with that. And I'm going to say that may have been disparaging of any of the lawyers in this case, because, I mean, it is a fact that on the record, some things were said about certain defense counsel that anybody who's an attorney would consider disparaging, unprepared, and unprofessional.
She's
so
looking at
I'm
Miss
gonna
Love too.
Address that and seek to cure that by just using that actual word. So that has changed with regard to my just general opening instructions about being the new judge on the case. Now we have to decide how we're going to instruct the jury about what to consider and what not to consider as to Mr. Copeland's testimony. Now, this assumes, this assumes that Mr. Copeland decides to testify. Obviously, if he
Which I don't know, it's looking like y'all are saying he's not.
You know, on Monday, not to take the stand at all, then it's a pretty easy instruction because it's disregard everything you heard from this witness. But if that's not the case, then does anybody have a proposal for how we are going to, and I think that's what the state had sent something on. And has the defense had a chance to look, and is there, I think Mr. Williams maybe has just sent over his proposed instruction, which hopefully everybody has gotten. All right.
All right, what are we going to do?
All right. So Mr. Williams' motion, his language, that looks pretty good to me. Obviously, we don't need to include the case law sites, but I mean, that looks like a good thing to sort of work from. Now, one thing I guess I was asking, but not very clearly yesterday, was it seemed like there was kind of a fairly clean break between the topics that were covered before the recusal motion and the topic that was covered after the recusal motion, and that being, I think, like on the one day, the question opened with, all right, now let's turn to the murder of Nutt or the murder of Donovan Thomas or whatever. And that was after the recusal motion had been filed. So was there any discussion of the murder of Donovan Thomas with Mr. Copeland prior to the recusal motion? Because it would be pretty easy to also say, not just with regard to dates and times, but anything about the Thomas murder, disregard, if that only came up after the recusal motion was filed.
Your Honor, with respect to any reference, I haven't had a chance to listen to all of it and read all of the testimony that and all of the questions that Ms. Hilton asked of Mr. Copeland. But I can say that at this time, I would ask that the court not instruct the jury as to disregard any specific subject, because.
Well, I'm wondering, so y'all have had the point of getting y'all all the testimony was, well, one of the points was so that you could look at it.
Yeah. I'm not saying I haven't looked at it. I'm looking for a reading.
Yeah. So, if there is kind of a break in terms of subject matter as well, that'd be an easy thing to instruct on. But does anybody know the answer to that? You do? Okay. What's the answer?
We have, yep.
I misspoke yesterday, but there were video portions of Mr. Copeland's statements on early morning hours of January 11th, 2015, as well as January, I think it's 21, 2015, played for the jurors.
Uh-huh.
They were small. They were like, quote unquote, real impeachment.
Right.
After that, though, after the motion to recuse was filed, is the wholesale playing of various recordings. So I don't think that it would be appropriate to say disregard everything. I have all my notes.
Okay.
And I have the transcript.
Okay.
But he did discuss things that you're talking about. He did discuss his relationship with Mr. Williams, his relationship with Donovan Thomas, with Mr. Kelvin Watts.
Right.
So
yeah,
he was getting there.
Okay, but if it's all that sort of background relationship stuff, that's not the murder of Donovan Thomas. That's all the background.
That's a great point. He's going to say it
again. So what
again.
I'm trying to sort out is,
if he gets on the stand,
had there been any testimony about the actual, here's the night of the murder stuff before the recusal motion?
So, Judge,
no, he didn't say anything.
When you say about it, in as much as it's relevant to the issue of the murder itself, that's the reason why I was asking the relationship between parties and all of those kind of issues.
That's not what I mean, and we can be clear about that. I mean, the night of the murder, the what happened, how the murder went down.
She's thinking about it.
I think it's safe to say that as far as Mr. Copeland is concerned, the specifics of the night of the murder information or evidence was given post-recusal motion. All
right. Is there anybody that disagrees with that? All right. Thank you.
Specifics of the night of murder.
She just clarified. She said, don't get me, Judge. Y'all let me know in the comments in the chat. Did Woody talk about or testify to anything that took place the night of the murder before Judge Glanville was recused or before June 12th? Do y'all remember anything? I don't. I don't recall, I should say. Get it together, Judge. Let's go. Travis said, yes, he did. Mr. Tesla said, I don't recall. See, and it's so funny that y'all are saying this in the comments. As much content if y'all has consumed, and I guess you could say it both, you could argue it both ways. Maybe y'all have been consuming too much, we just forgot about Woody, or we just haven't seen enough. But so many of y'all are saying, nope, I don't think he did, I don't remember. Kyle said, I thought he said he did that one time. I don't think he did, I don't recall. LJ got it. What you mean? What do y'all think the jury is going to say? Hey, jury, do you have the ability to remember? All right, let me rephrase that. Strike that. Do you have the ability to forget everything that Mr. Kenneth Copeland said, especially regarding what happened with the murder of Big Nut? They're going to say, who? What? Who is that again? I've been sitting in my hotel room watching 6 seasons of Murder, She Wrote for the past month. I don't know. I don't even know who that is. Kyle said, I'm sure he said it at some point. We'll see Monday. I want to skip forward, but I don't want us to get into buffer land again. And we'll get all the phone calls in once we're done with this section. I see y'all in there wanting to call in. I'll get y'all up here in a second. And didn't Judge Whitaker say that she was going to get all of their notes too? Mr. Brown said he only said, what you mean? I can't recall. Can you say that again? Absolutely. He didn't say much about anything, but definitely can't forget his testimony. That's a good point, Stephanie. Because as Wealthy Wisdom said, that'll be the question.
And Your Honor, would the court consider the state's position that in characterizing any evidence in any way, it could imply to the jury that certain other evidence does not fall into that category? So in other words, any evidence of the night of the murder, I'm not certain how the court will be instructed. I'm not either. That's what we're supposed to be tailoring today. That's what I wanted y'all to be giving lots of thought to. But yeah, no, I want to tailor it in such a way that I don't mislead the jury about anything. But y'all all agree that we have to tell them to disregard some of it. And I mean, yeah, maybe the cleanest thing to do is, XYZ date, but people don't normally think about their lives in, June 3rd. Okay. I know exactly what June 3rd had to do with, unless it happens to be their birthday or something like that. But so, yeah, I'll consider all of what you want to offer me, but okay.
Personally, and I'm not speaking for, I don't find my notes as well as a transcript, but my notes have more things, I guess, they were my notes. But I don't have anything specifically talking about the Donovan Thomas murder before Mr. Weinstein filed the motion to recuse. I do have like a January 11, 2015 interview by Detective Thorpe of Mr. Copeland.
Yeah.
It is admitted over objection, and it was played from 3:29:46 to 3:30:13. And I have to go back and remember what that was about, but I have little things like that, but I don't have any specific.
That's very helpful. And I knew there were a couple of small snippets of videos played. So if you've actually got the timestamp as to what parts were played, then it's easy enough to have somebody look at those snippets and see what it covered.
Can I announce?
Yeah, and Brian Steele's basically saying that what we've been saying. He may have talked about it, but between the 12th and the 14th, can we remember? When was it? That's what they'll have to look into their notes and find
Now
out.
or
Yeah.
so everyone can check. I have States Exhibit 378Y, as in Yankee, B as in Barry, 6, and these are the time slots, 6:46:34 to 6:46:44, and that's the January 28th, 2015 interview.
Okay.
And then I have the January 11, 2015 interview marked at States Exhibit 358A as in Elisa, and it's at the time I just said, which is 3:29:46 to 3:30:13. That's what I have. And then I have nothing else about specifically his interviews after the killing.
Okay, 3:29:46 to
3:30:13.
Okay, thank you.
And that's at 358A as in Elisa.
All right, and I think that's our review had only revealed those two, anything from those two videos also. All right, anybody else have a different recollection about either more videos or the specific topic of the night of the murder having come up prior to the recusal motion? If so, please let me know.
Yeah, she'll probably be back,
All
Mr.
right.
Brown.
Silence. All right, turning back to Mr. Steele's proposed instruction. You're saying that as to collecting their notes, they're going to be sealed for the record. Why not just destroyed? And I don't even know if your mic's working right now. We might need some more batteries, but
I was given more batteries, but this should be working, I hope, anyway. I just, from doing death penalty cases, that we don't destroy anything, but we don't get to look at it. The court can look at the notes, I guess, but it goes under seal. That's how I've always been taught.
I mean, why would there be any relevance whatsoever, even on appeal, to what jurors might have written down about something we then take from them and tell them to disregard?
You just never know.
This is just
Okay.
how
I mean, if it were a death penalty case, I would do it that way, but.
I'd have to look at the law, though. But
Okay, well.
But I can't answer your question other than, yes, I understand at the end of the case.
All right.
No one gets
Frankly,
their notes.
I don't need to tell them what I'm doing with them anyway. So if I do seal them for the record, I'm not going to tell them that. If I'm going to destroy them, I might tell them that. But so if you want to give me a law on that, great. All right. Now, one other thing that I propose to do, because we're telling them there's this chunk of testimony from a couple of days that y'all need to ignore entirely, disregard entirely, don't give it any consideration. What I propose to do in addition to instructing them on that is to then do some version of, and Ms. Persfield found a case that was pretty recent where a court had done this when they were having to say, ignore all that evidence, disregard it. They actually kind of said, and if there is anybody who thinks they can't, let me know. And I would propose to do that whenever I give this instruction, so that if there are jurors who are like, no, man, I just cannot do that. Once I hear it, I can't unhear it. Then we can know that. We can excuse those jurors. And I mean, I guess if it's 8 jurors that say that, then we might have a mistrial. But
oh, hold on a second. So we were talking about this in the chat. So obviously there are 12 jurors, but if 8 of the jurors, 8 of the 12 that are there, obviously they've got alternates and they've got so many different replacements. But if 8 of them say that, yeah, it's impossible for me to remember what he said from the 12th to the 14th, then it's going to be a mistrial. Now, we led up to this and we gave a lot of background information. I asked you guys in the comments and in the chats, what do y'all think? Do you even remember anything that was said on those 2 days? I don't know. It's going to be tough to see. I want y'all to tell me in the comments and in the chat, what do y'all think? Would you be able to forget it? Have you already forgotten it? Because as Doug Weinstein said, when he filed his motion for a mistrial, he said, if you tell somebody, don't think about a flying elephant, they're going to think about Dumbo. So if you ask the jury, hey, don't think about Lil Woody's testimony, are they going to start thinking about Lil Woody's testimony? It's almost impossible. But also, you have to look into the fact of, what did Lil Woody actually say? I don't know that any of us can remember. I really can't remember other than some memes, but y'all have to tell me. And I know some of y'all wanted to call into. Mr. Tesla said, I don't recall. I want to acknowledge some of these super chats too before we keep it going, and I will get some of y'all in here. We still got a ton that we've got to cover. So let me see who we got in here. It looks like we got Floyd over there is ready to call in, but before I get Floyd up in here, and let me make sure that he can hear me. Boom, there we go. All right, so Floyd can hear me now. I'm gonna bring him up in a second. I want to acknowledge some of these super chats and some of y'all that sent over on the Cash App too. Y'all are showing major love. Let me get the Cash App first. Shout out to Jaina in the building. She dropped a 20 bomb. And she said, for the best. Look at her. Shout out to Jaina. I appreciate you. And then we've got Amy over there. She dropped the 2 bomb, the 5 bomb. And then she gifted 15 memberships. Wow. Shout out to Amy. I've actually got some dope members only content I'm gonna be dropping for y'all over the weekend. We got to chop it up with Henry Resilient the other day. We'll be dropping that video along with a couple other things. So not only do you get that with the memberships, but you guys get custom emojis that you can use in the chat, and you get first access to all the videos that I drop here on the ClassE Beats YouTube channel. So shout out to Amy for that. Big shout out to Mar for dropping the 99-cent bomb. It's not required that y'all send in super chats and Cash Apps, but I do appreciate it. It really does help the channel continue to grow. So thank y'all for supporting. Look at Floyd dropping all the emojis in there. Amy said can't hide the elephant. Yeah, Amy. Oh man, shout out to Amy. Let me see if I can get Floyd up in here. Let me make sure we're good. The audio settings, echo cancellation. All right. Floyd, can you hear me?
All right. Floyd, can you?
Yes, sir. Can you hear me?
Yeah, there he is. Shout out to Floyd.
Yeah, there he is. Shout out to Floyd.
Hold on. Floyd, do you still have the YouTube on? Because it sounds like there's an echo. So you might have to turn off the YouTube.
I got you. I got you.
Shout out to Angela. Thank you.
Is that
Angela.
better?
Yeah, perfect, man. Go ahead. What's on your mind, Floyd? Thanks for calling in too.
Well, man, my pleasure. First off, I really called to ask you a question, but I want to say, because I had to slide off yesterday, congratulations on 40K.
Thank
when
you,
get
sir.
50K, I'm booking a flight because I gotta come celebrate, man.
Let's go.
Real talk. What I want to know, First off, I don't think Woody gonna testify, but I want to know what are your thoughts and what do you think Glenville is thinking right now as he's watching all of this unfold?
Yeah, that's a great question. Somebody mentioned it in the chat earlier. Dang, I wish I could remember who it was, but they had a great question saying, "Do you think Glanville's best outcome for either his career or just his reputation would be not guilty verdict at the end?" Right. And that's a tough question because with Glanville, I know he's going about his life. He's doing what he's got to do, taking his comfort breaks and all that. So I don't think
you don't think he's watching this whole thing?
Oh, he's absolutely watching the whole thing for sure. But what is he thinking was your question. If I were Glanville, I mean, he's been long forgotten. All the motions have been filed. They've been they've talked about, the just calling them Glanville or just Judge Glanville, not giving him his full title. So we've long past moved on from Judge Glanville. So I think he's moving on with his life. He's probably passing some of them in the hall as he's walking through court back and forth and maybe just giving them dirty looks. But other than that, I think he's moving on with his life, honestly. He's been doing this a long time. He is the chief judge. So we got to remember that too. I mean, Glanville's not a scrub. So this is just thank y'all for getting me up out of here because I'm ready to go on to my other cases and move on. So I don't think he's giving it a second thought. I know for a fact that he's watching the rest of the trial, though, for sure. Thank you, Angela.
That's fair. And the reason I asked that question, it was kind of like a little setup. Whenever we talk about Woody, first off, I don't think that it's in the state's interest that he come back at all. I don't think he'll testify. But just like we can't forget about the things that Glenville done, you can't ask the jury to forget about what it is that Woody said. There are monumental moments in this case. And though we ain't talking about a death penalty case like she was just saying as far as the notes and all of that, we talking about somebody's life, somebody's freedom, you know what I mean? That's at stake right here. And whenever we get to saying, hey, you can't or don't think about, bro, I don't care what it is that somebody's done. You ask somebody to do something that's humanly impossible. This ain't The Boys. This ain't no fairy tale. This ain't a Marvel comic. Once it's heard, it's out there. It's just what it is. That's why they say, I tell people all the time, 6 and stones may break my bones, words never hurt me. Biggest lie ever told. Because once somebody say something to you, you got somebody right now that's 37, 38, 40 years old who's still struggling with something that they heard at 6, 7 years old. You know what I mean? So we got to take that into account. The truth of the matter is, bro, this should be a mistrial. All y'all that's out there paying good tax money in that county need to be refunded or given some type of reparation for this time and this waste that's going on. But yeah, that's my thoughts.
Yeah, and here's the thing, going back to Glanville, look how this entire Fulton, look at the DA's office. Look how Fannie Willis has been functioning. Look at everything that went down with her and Nathan Wade and everything that's going on in this Trump trial. I think she's in a hearing right now, her 5th hearing about how she handled and conducted herself during that trial. So, I mean, Fulton County, they're chilling right now. You can see how much grace that Miss Love and Miss Hilton are even getting from Judge Whitaker. So I think they're cool. I think Judge Glanville's just like, hey, we're going to keep it moving. I'm the chief judge and the YSL trial is behind me at this point, because if you know some of the things that are going on from Fulton County, even when I served on the grand jury several years ago, there were so many cases that were backlogged. And I think they're still dealing with some cases from when COVID happened, because everything got put on hold once COVID happened. So even if Judge Glanville, I mean, they said he got a slap on his wrist or the bar, someone contacted the bar about how he handled himself, that the chief judge of Fulton County is not going anywhere. He's got too much work to do. They need him. And as long as Fannie's in office, I don't see anything happening to him. But
yeah, no, I don't see it happening either.
All right. So last thing before I get you up out of here, what do you think is going to happen on Monday? Firstly, with the jury, what are they going to say? And then secondly, if they move forward, what's going to happen with Woody? What do you think?
I also think that it's interesting she made that statement during this account here, because I don't care who it is. I didn't talk to people who's on jury, this, that. You watch other coverage of the case. They tell you that you can't, but you gonna do it. Yeah. I think like point blank period. And for you to get up there and say, if 8 people say no, it could be a mistrial, bruh, I think it's gonna be a very interesting Monday, because like I say, you can't tell somebody to unhear something and they not think about it. I don't care what it is. All y'all listening to the live right now, don't think about if it's raining outside or not. somebody gonna go look. It just is what it is.
That's a great point. Do you think Woody's going to
Uh,
testify?
I don't. I think he'll come back up. I don't think it's in the state's best interest though. But no, I don't think he'll testify. But I mean, I don't think we've seen the end of him. And at this point right now, that boy done got another type of bag behind this whole little case too. Boy, he gonna get up there and show his ass.
Yeah, it's going to be crazy, man. He knows exactly what he's doing. Shout out to Floyd, man.
Yeah.
Floyd, the real deal, Neil in
Hey,
the building.
one
Big
last thing
supporter.
before I get up out of here.
Absolutely.
One
man.
last thing.
Yeah.
I don't like the ratio to likes to viewers on this video. So right now, y'all go hit that like button. It's free. Share the live. Go ahead, do what you got to do. Hey, salute to you, sir. We appreciate all that you do.
Salute to you, Floyd. I appreciate you, man. Glad you're doing well. And you know, you can call in anytime, brother.
Absolutely, man.
Y'all give it up for Floyd, the real deal. Neil in the building, my dog. Again, another one of the biggest supporters in this community. And if y'all haven't heard or you don't know, Floyd is a music artist. If y'all want to check out some of his music, you can find him most places at Pretty Boy Floyd. And you can definitely find him right here on the ClassE Beats YouTube channel every Monday, Wednesday, and Friday, sharing some of his music on the Song of the Night Live. All right. So we've got a couple more topics we're going to get into. I think we're going to end it right here on this first one, but we've got some more motions were filed. If y'all want to call in, the link to call in is in the description. Y'all can call in at any time. And then once we're done with each topic, I'll go ahead and bring y'all up and see what y'all are thinking. Let me check out a couple comments in the chat. I want to make sure I didn't miss anything. We got Javi in here. Our resident attorney is in the building. Where is he at? I saw him in there a second ago. Where'd he go? Where'd he go? There he is. Shout out to Mr. Javier M. Bailey in the building. Our resident attorney here on the Music Morning Show. Always good to see him. Javi, if you got a second, man, I'd love for you to call in and hear your thoughts. Just let me know if you decide to do that. Travis is in the building too. He said much laughter when someone's life is on the line from the judge though. Yeah, a lot of people aren't rocking with that. A lot of people aren't rocking with Judge Whitaker cutting up on the stand. Let's see. And it looks like we got 50%, almost 50% of y'all have liked the video. What else are y'all saying? Charlotte is in here. Shout out to the new timer. Charlotte says, yes, I like y'all, but yes, I like y'all is what I think she meant to say. But I'm saying they didn't target him. Something happened with his name tied to it. Crimes and drugs and racketeering. Are you talking about Young Thug? Yeah, I think here's the issue, and the thing I keep bringing up and have brought up multiple times is I want to get to the facts of the case. I want to actually find out if the state has something here. But with all the foolishness, all the errors, all the blatant disrespect, not only for this court system, but for their colleagues, for the defense, for this man's life, it's just kind of put this huge stain on this entire trial. And everyone just wants it to be over at this point. Because imagine you don't want to be sitting in jail for this long. And we haven't been able to hear all the facts. We have the indictment. We see what they're saying they're being charged for. We don't know the facts. We don't know the facts of the indictment. We don't know the facts, all the facts that they're trying to present. And everything's been put on hold because of Glanville, because of ex parte meetings, which we're going to get to in a second. And all of this is just a mess. So I can't even have that conversation when these guys have been sitting in prison for 2 years for something that they may be found not guilty of. And here on the Music Morning Show, you are innocent until proven guilty. So I don't know. We got a couple more super chats coming in. Shout out to Amy. She dropped the 149 bomb. She got the cake over there. Let's go. And then she's dropping the weights in here too. Look at Amy going crazy. What did she say? She said, y'all get a sticker or a super chat and show ClassE some love. Shout out to Amy. Appreciate you. Lauren Robinson said, yeah, Gotti's case didn't even take this long. Yeah, he's still sitting there. Let's go ahead and get into our next topic. Let me see. So this is going to be an interesting one. And let me double check before we keep moving and make sure nobody else called in. We're going to leave. Okay. We're good. We're good. So we've got a new order, and this is tough. we're gonna have to figure out what's going on with Judge Whitaker. I know I've been hyping up Judge Whitaker, saying how I like that she's kind of a straight arrow. She's been following the guidelines and moving through this case at a very methodical way, making sure that she doesn't miss anything, making sure she's keeping Miss Love in check, and that they have everything together. But most recently, in this new order that she sent out, a lot of people are disappointed, and I know specifically, man, you got Doug Weinstein is disappointed here as well. So we're going to get into it and check out what's going on with this order here in a second. This is the order denying defendant Kendrick's motion for mistrial and supplement to the same. This is the state of Georgia versus DeMonte Kendrick, aka Yak Gotti, aka Mr. Doug Weinstein. This is Judge Whitaker responding. Right now, we talked about this briefly on the last video, where basically in that last motion, Doug Weinstein, or I should say Yak Gotti's representation, Doug Weinstein said, hey, y'all, you're going to have so many issues when it comes to this jury trying to forget everything that they heard from the 12th to the 14th, along with so many other things and so many missteps that have happened during this trial, that there's no way we can move forward. And Yak Gotti has been holding off for a while from taking that step and asking for a mistrial. Now we're going to hear back from Judge Whitaker and why she says that she is going to deny his motion for mistrial. Order denying defendant Kendrick's motion for mistrial and supplement to the same. Before the court is defendant Kendrick's July 23rd, 2024 motion for mistrial, supplemented on July 31st, 2024. The court has also considered the state's response, oral arguments by the parties, the transcripts of the June 7th and June 10th, 2024 ex parte proceedings, and applicable law. The motion for mistrial asserts 3 grounds for mistrial, with the supplements asserting a related 4th ground, that it is 1, impossible to redo the proceedings that occurred on June 12th, 13th, 14th, and 17th before the jury in the interim between defendant June 12th, 2024 motion to recuse the predecessor trial judge Glanville, as we know, and his ultimate recusal. Number 2, that the defendant's constitutional right to be present at a critical stage of the proceeding was denied when neither he nor his counsel were present for the June 10th, 2024 in chambers on the record ex parte discussions amongst the court prosecutors Love and Hilton, counsel for witness Lil Woody and witness Lil Woody himself. And then the third thing, the defendant's due process rights were violated when the predecessor, Judge Glanville, allegedly aligned himself with the prosecution teams by his comments during the June 7th, 2024 in court on the record ex parte discussion between the court and prosecutors Love and Hilton, and allegedly coerced witness Lil Woody into testifying during the June 10th ex parte meeting. I love the language she's using here, saying allegedly. No, come on, they did. All right. And 4th, as raised in the defendant's supplement, that bias of the predecessor judge, Judge Glanville, constitutes due process violations of the defendant's rights under the Constitution of the United States and the state of Georgia. Kendrick also asserts that the motion for mistrial was goaded by the state when it requested that Judge Glanville hold the June 10th ex parte meeting, which has been the subject of much discussion in this case. That's an understatement. Absented Kendrick from the meeting and joined with Judge Glanville in the coercion of witness Lil Woody, which I still wonder if Brian Steele, if he gets to cross-examine Lil Woody, is going to ask him if he felt coerced and if they can revisit this at some point. It'll be interesting to see. Impossibility of addressing or redoing the proceedings post June 12th, which are void. Defendant Kendrick raises issues that the court has already addressed in granting defendant Young Thug's motion to invalidate and strike all proceedings that occurred in the above referenced case on and after the initial motion to recuse Judge Glanville was filed on June 12, 2024. And if y'all remember, Judge Glanville He was asked to recuse himself on June 12th, and he said, nope, we're going to keep going. So they kept going until he threatened to throw Brian Steele in jail. He heard back from the Supreme Court, and the Supreme Court said, y'all got to shut it down. We can't move this forward anymore until we figure out what we're going to do with Glanville. And then in comes Judge Krause. She says he didn't do anything wrong, but because it looks weird, we're going to go ahead and get him out of there. And he's gone. So now we're trying to fix that entire mess. As noted in the order granting defendants Young Thug's motion, the court has been working with the parties on which testimony and evidence should be resubmitted / represented to the jury in this case, and whether any other evidence at issue will be stipulated to as well any needed ruling and or instructions related to the same. She's got a note here. She says the order granting Young Thug's motion noted that the court would work with the parties, and since that time the court has done just that, formulating instructions and addressing evidentiary issues with the input of all parties, which is what we've been doing for this entire week for the most part. As such, the court does not find that there is any impossibility to addressing these issues, and therefore there is not a basis to grant defendant Kendrick's motion for mistrial on these grounds. Interesting. So she's saying, hey, well, we should, excuse me. She's saying we should be fine. We should be able to go back and figure all this out because as Young Thug already requested and I granted, we're going to strike everything that happened from June 12th on from the record. All right, maybe we'll give her that. On June 10th, 2024, at the behest of Prosecutor Love, the predecessor, Judge Glanville, held on the record in chambers meeting with Love and standing counsel Lil Woody, Caleb Bumpus, and I'm sorry, standing counsel for Lil Woody, Caleb Bumpus. I read that wrong. June 10th, 2024, transcript of ex parte, page 3-22, following a recess at which time Love departed the meeting. Lil Woody and Prosecutor Hilton joined the meeting. Okay, and then we have a note here too, talking about the ex parte meeting. Defendant Kendrick's motion mentioned a June 12th ex parte meeting, which the court believes to be a error as the court is not aware of any ex parte meeting occurring on June 12th. Okay, yeah, we don't know about that either, but we'll keep it moving. Defendant's motion raises several challenges of this ex parte meeting. Did defendant have the right to be present? We talked about this as well. Did the ex parte meeting amount to coercion of Lil Woody's testimony? Have we even talked to Lil Woody about that? I don't think we've heard from him about that yet. And did the predecessor judges, Judge Glanville, comments and participation in the ex parte meeting rise to the level of due process violations? All right, Judge Whitaker, she says the ex parte meeting was at a critical stage and violated Kendrick's rights. The defendant argues that the June 10th ex parte meeting was at a critical stage and violated his rights since he was not permitted to be present. A critical stage is one in which a defendant's rights may be lost, defenses waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in some other way, as we can see in Brennan versus State. Defendant is correct that this meeting was about more than just the parameters of Lil Woody's immunity, and whether he understood its potential ramifications. What? So she's saying Mr. Weinstein is right in saying that this meeting was about more than just the parameters of his immunity and whether he understood the ramifications. With that being the case, wouldn't this be considered a critical stage? Interesting. The initial stage of the meeting before the first break centered on the prosecution's coercion with whether Lil Woody's main counsel was laboring under a conflict of interest. This court sympathizes with Mr. Melnick's understandable indignation, oh my goodness, at having his professionalism and his loyalties to his client questioned. The court likewise appreciates defense counsel's umbrage. Okay, well, it's going to keep it moving. I'm not even going to try with that one. The initial stage of the meeting before the first break centered on prosecution's concern with whether Lil Woody's main counsel was laboring under a conflict of interest and with the logistics of handling Lil Woody's testimony with stand-in counsel. But because these topics were all ancillary to Lil Woody's immunity grant, the topic of the meeting remained at its core and asserted by the prosecution Lil Woody's immunity grant. What? So she's basically saying that everything that was discussed was still having to do with Lil Woody's immunity. But then up here, she said they're correct and the meeting was about more than the parameters of his immunity. This is confusing. Because the meeting dealt with Lil Woody's grant and its ancillary issues, it was not a critical state of the trial at which the defendant had a right to be present. Oh my gosh. This is the most... Judge Whitaker, I'm disappointed. Just like I was disappointed in Judge Krause. Again, I'm not a lawyer. Most of y'all watching this aren't lawyers, I would assume. But just reading this and just looking at the facts of what happened, so much was said during this ex parte meeting. And the judge was removed after this. I mean, his representation was fired and let go. How is this not a critical stage? I'm missing something. I don't get it. Maybe we should just see Snyder v. Massachusetts, where it says criminal defendants has a right to be present with when his presence has a relation reasonably substantial to the fullness of his opportunity to defend himself against the charge, but not when his presence would be useless or its benefit but a shadow. Okay, so this is essentially saying that anything they could have said or objected to wouldn't have applied to Mr. Kendrick. But if Lil Woody in that ex parte meeting is saying, I did these crimes, that seems to me that it would have some impact on Yak Gotti, aka Mr. Kendrick, aka Doug Weinstein. But she goes on to say the presence of a defendant in a condition of due process to the extent that a fair and just hearing would be thwarted by his absence, and to that extent only. So what does she just want to wait until Woody gets on the stand and then he says, yeah, this is what I said in that meeting. I said I did these crimes and also I felt coerced. And then we're going to say, okay, hey, I was wrong. It looks like this was a critical stage. We've got it in the transcript. What else do we need? We've got the entire transcript showing us and telling us everything that went down. I mean, can we get Glanville on the stand and find out from him what happened? So then maybe we can determine if this was a critical stage. This is, oh man. The fact that here discussions included what testimony would be subject or would subject the witness to a charge of perjury, what would subject him to punishment for contempt of the order compelling his testimony, and what that sanction might entail, even if incorrect, does not change the analysis. So a judge can just be in his chambers with the prosecution talking to a sworn witness and giving them incorrect information and coercing him to testify. Has nothing to do with the defendants. Okay. Defendants' rights were still not the subject matter under consideration. I understand, but man, no right to be present at the hearing to compel witness testimony pursuant to immunity grant. And she's got another note here. We'll read through it. Lowry found that because the hearing also included discussion and ruling on the defendant's motion, a mid-trial motion in Lamine regarding the witness using street names during the testimony, absence of the defense violated defendant's statutory right to be present. though any constitutional errors was waived. Here, there was no ex parte hearing or discussion of any defense motions. This analysis confirms that the key to whether the defendant has the right to be present for witness immunity proceedings is whether for some reason the defendant's rights are also a subject matter under consideration. So maybe that's the reason they didn't say anything when Lil Woody said that I did these crimes. They just kept it moving because they didn't want to have to allow the defense to be there. Maybe the state is smarter than we think. All right, let's keep it moving. Judge Glanville improperly coerced Lil Woody to testify. Separate from any defense rights to be present for ancillary proceedings coercing witness immunity, defendant had a right to a trial free of coerced testimony. Oh, thank you. I'm so glad you pointed that out. Defendant asserts that certain arguably inaccurate representations made by the prosecution and Judge Glanville to Lil Woody about the law of derivative use immunity, the applicable, I got it, y'all. Statute of limitations relating to what crimes the defense does not specify, and the length of his possible incarceration for contempt coerced Lil Woody into testifying. Under both the federal and state constitutions, a criminal defendant has the right to be present during critical stages of this trial. Defense counsel should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage of the trial is being coerced to testify. Okay, so she agrees. I'm guessing she's going to say that he wasn't coerced. So she agrees. If he's being coerced to testify, yeah, you guys should be there. But in Webb versus Texas, is the touchstone for evaluating claims of coercion by the trial court of a witness testimony. Archer v. State provides another example of a trial court overstepping its proper role of neutral arbiter and rendering involuntary a witness determination whether to testify. Here, Lil Woody had the benefit of counsel. Check. Judge Glanville did not, on the whole, use intimidating rhetoric. What? Get Judge Glanville on the stand. Get Judge Glanville on the stand. Oh, man. Woody, you have to testify. I know you're watching this, Woody. You have to testify, man. You have to get the cross-examination in there, and you have to let Brian Steele, Doug Weinstein, Bruce Harvey ask you if you felt that Judge Glanville was using intimidating rhetoric. How can you know that from a transcript? What? And even reading it, y'all read it. We reviewed the transcript several times. How would y'all feel if you're in there with counsel or not, and the judge, the chief judge of Fulton County, is telling you, hey, listen, I get you might not want to testify, and that's fine. That's okay. You don't have to testify. You have constitutional rights. You can plead the fifth. It's okay. And I'm saying it in a non-intimidating voice. But just to let you know, Woody, I've got 20, 30, 40, 50 more people that are going to have to come into this trial. That's going to take some time. And if you want to plead the fifth, you don't want to testify, that's fine. But I can guarantee you that you're going to sit in jail until all those witnesses are heard. Until we finish up everything with each one of these defendants. So if you want to do that, you can go ahead and do that, Woody. It's okay. I'm here for you. Miss Bumpus is here for you. Miss Love, she's got your back. Just want to let you know. Are we really That's what we're saying, Judge Whitaker. That's how Glanville said that to Lil Woody. Okay, fine. You want to say that? We'll take your word for it. Not. I want Judge Glanville on the stand. I want Woody on the stand. Woody, you have to testify. You have to tell Brian Steele, listen, this part of the transcript, when Judge Glanville said you were going to have to stay in jail if you pled the fifth again until the trial was done, essentially. Did you feel intimidated? That's what we need to hear, because this is some BS. I don't... Even Kayla, even his counsel was saying that she was nervous. Even his counsel said she felt intimidated. Not only did she say that on the stand, but she said it on YouTube. She said, whoo, y'all, I was nervous. Boy, y'all cannot imagine the pressure I was under. Come on, Judge Whitaker. Here, Lil Woody had the benefit of counsel. Judge Glanville did not, on the whole, whatever that means, use intimidating rhetoric, but rather sought to ensure that Woody understood the nuances of the decision he had to make. And he explained that many of the decisions about what could happen to Lil Woody were not his to make. They weren't his to make, but were up to prosecutors. That's some BS, man. Still, some of the information provided to Woody may have been inaccurate. Judge Whitaker, this is crazy. So not only is she throwing Judge Glanville another bone, just like Judge Krause did, and say, hey, listen, all he was saying was it wasn't his decision. This is what possibly could happen. But yeah, still some of the information provided was inaccurate. Judge Glanville can just say whatever he wants to. While it is likely that Woody was not induced by an inadvertent or other inaccuracy to testify, the cleaner approach is to simply to permit this issue, acknowledging past inaccuracies, and advise Lil Woody anew. So she's saying we're just going to look past this. They may have said something that was wrong here or there, but I highly doubt that Miss Hilton saying, hey, you can do whatever you want to on the stand other than saying that you killed Big Nut, that really didn't have any factor into Woody making his decision to testify. Let's just keep it moving. This is the course that the court has proposed and the parties have affirmed in, I don't know that word. I'm going to mess it up. Also, they say Lil Woody has since been recalled to open court on August 6, 2024, and in the presence of his counsel, Melnick, who also privately consulted with and advised with Lil Woody, was provided clarifying and correct information, only matters potentially impacting his choice whether or not to testify. All parties were present and consulted with the court prior to Lil Woody being advised. All right, so hey, the defense knew about it this time. Shout out to Judge Whitaker for doing their job at least. Bias on the part of Judge Glanville constitutes due process violations based on the comments in the ex parte transcript made by Judge Glanville about counsel, both the defendants and for witness Lil Woody, as well as about outside agitators, as he said. Defendants asserts that Judge Glanville during the conference revealed his partiality to the state. What does this note say? Judge Glanville's remarks regarding outside agitators are virtually identical to the remarks he had just made on the same topic in open court, remarks which he addressed to all counsel. So he's talking about the prosecutors and the defense. All right. The accurateness of such characterizations and discussions, this issue has been mooted by the recusal of the judge from this case. So he gone, don't worry about it. Stay out your feelings. Wherefore, for all the foregoing reasons, defendant Kendrick's motion for mistrial and supplement to the same are hereby denied. Ordered this the 8th day of August 2024. Page Whitaker. Doug Weinstein was not happy about this. What did he have to say over on X? He said, the damage done by Judge Glanville and the state has infected the entire body of this trial. And emergency amputation of the judge can't save it. He's so good with his words, man. Nevertheless, we will continue to fight for justice and the eventual freedom for Mr. Kendrick. Then he goes on to say this. I have requested a certificate of immediate review. There he goes. So an appellate court will have the opportunity to weigh in on the important issue of mistrial instead of wasting further time and ClassE beats Amy, Mr. Tesla's resources on this. I don't even know how to say this word, on this trial. I'm sure it means messed up trial. All right. No remedies fashioned by this honorable court can cure the due process violations that have repeatedly occurred over the past 19 months. No instruction can cause this jury to unhear Lil Woody's testimony. A fair judge going forward can't cure a biased judge's presiding over this case in the past. What do y'all think? This is wild. Doug Weinstein's not happy. A lot of y'all in the comments and in the chat aren't happy. And I know Yak Gotti and some of the other defendants aren't happy about this either. Did Judge Whitaker switch up on us? We thought she was for the people. Is she showing her true colors, or did she follow the law? Did she make the right decision in denying this? Y'all have to let me know what you think. We got a couple more super chats in here. Oh my gosh. Shout out to Amy in the building. She says shout out to ClassE and his white girly sultry voice. Yeah, if y'all missed that, you got to go back and watch that episode. I don't know what episode it was, but we out here going crazy. She said ClassE using his library soft-spoken voice. That's how Glanville said it. Said, listen, Woody, I know you're trying to do the right thing, but if you don't testify, I'm going to keep you in jail for a long, long time. Take that as you will. I'm not trying to I'm not trying to intimidate you. I'm just giving you the information. That's what we're doing. What does Lauren Robinson say? Monday, I will make a decision if this is all a strategy. Yeah, we'll see. It's all going to go down on Monday. We got a couple more things we're going to get into. Let me see if anybody else decided to call in, because man, I've got, how many other things did I have? We got that one. We got that one. 1, 2, 3. We got 3 more things. I'm going to try and make these quick. Mr. Tesla says, shut up and get on the stand, Judge. Amy says she sent a comment. Where'd you send a comment to? Where? Did I miss it? Let me go back and make sure I didn't miss any super chats. Hold on. You saying a super chat? I saw your shout out to, I missed it, Amy. What did you say? Oh, okay. Is this what she's saying? She says, how do y'all think this will affect Fannie? If this is a mistrial, if this is a mistrial, Fannie is going to be in some hot water. Oh, okay. I got you. Fannie is going to be in some hot water. Wasted our money. Embarrassed herself. We're going to be able to point to the fact that she wasn't even involved in this trial other than writing one response. The biggest trial in our history is crazy. Mixed System Answer said you miss it. And Amy says too long. I sent it to you. Let me see if I can find it. Oh my gosh. Here we go. Fannie Willis is a perfect example of how important it is for voters to become educated about who they are voting for. You know, I shouldn't read this. I should make her call in. but I'm going to read it. I'm a nice guy. And it's Amy. Fani Willis is a perfect example of how important it is for voters to become educated about who they are voting for. She should not be winning re-election this year. This is a DA who spent millions prosecuting public school teachers for helping students cheat on standardized tests. Those millions could have been better spent funding Fulton County's failing schools or their failing prison system. The actual problem, she says. Now she and her incompetent prosecutors are repeatedly violating the rights of these YSL defendants just so she can claim she is tough on crime. Imagine how they are violating the rights of young black men who can't afford the best lawyers. Yeah, we talked about this. While she is busy spending millions on this YSL case, the backlog of thousands of violent crimes cases in Fulton County grows and grows. She is awful. And you know what? I'm going to say what others refuse to say out loud. Her case against Trump is bullshit. The RICO charges against him make no sense to any objective, nonpartisan reviewer. The Supreme Court and Fannie's affair saved him, but these YSL defendants are still going through their scam trial. Fulton County, do better. Amy for president. Yeah, and y'all know Ashley Merchant got that Trump situation on hold. It is on hold right now because Fani Willis just completely messed that whole thing up. So we may get into that at some point. I want to see what the outcome of her hearing is today, but it's a mess. And I agree with everything she said 100%. Great word there, Amy. I wish you would call in, but whatever. You can class. You had a long night in the morning. That's true. I'm off this morning. Remember? I know. Thanks for reading. Thanks for sending it. Very well said. Very well put. Boss said, it's on both sides. Judge Glanville loves saying that when the prosecution messed something up. Why are you so fussy? All right, let's get into this next one. We got to get into this next one. Shout out to Joseph Papp. So this is a good one too. Y'all are going to love this because we got to look at what happened here. So we've got another ruling. Oh man. We've got another ruling when it comes to the entire ex parte meeting. Judge Whitaker out here putting in work and deciding what we're going to do moving forward and if there is even a case for a mistrial here. So y'all check this out. This is the state of Georgia versus Young Thug, aka Jeffrey Williams, aka Brian Steele. What does Judge Whitaker say? This was filed yesterday. Order regarding alleged ex parte Brady violation. We talked about what the Brady violations mean. And I can explain it for y'all a little bit later too, but I want to go ahead and get into this. Defendant Young Thug made an oral assertion on August 2nd that during the June 10th, 2024 in Chambers ex parte meeting, there was an off the record discussion amongst witnesses Lil Woody and his attorney Caleb Bumpus and prosecutor Simone Hilton, in which Lil Woody discussed the murder of Donovan Nutt Thomas and made a statement or statements inconsistent with his June 10th, 2015 statement to the police, which, if not disclosed, would constitute a Brady violation. Okay. The court heard testimony concerning that matter on August 5th, 2024 from Ms. Bumpus and Fulton County District Attorney's Office Investigator Long, who was also present during part of the June 10th, 2024 ex parte meeting. So two people who were in that meeting. Two people were in that meeting testified. We got to check it out here and see what went down. In case y'all don't remember, I'm not going to lie. It was rough. It was hard to watch. So here was Kayla when she got on the stand.
Prosecutor, yourself, Mr. Copeland, not to disclose any of the contents of the meeting.
All right, we are not going to replow the issue of Mr. Steele being held in contempt. That is moot. So to the extent that this is going to that, move on.
Okay. That's where I was going.
All right.
Thank you. No questions.
So this is what Judge
Anybody
Whitaker
else?
is talking about in her order.
From the defense team side. Okay. Ms. Love, do you have questions for Ms. Bumpus?
A few, Judge, just a few. Thank you. Ms. Bumpus, you were asked by, I believe, Mr. Steele, whether Judge Glanville ever handed Mr. Copeland anything. Do you remember being asked that question?
No.
Okay. Do you recall telling Mr. Steele or Mr. Shard or either member of the defense team this morning that in the June 10th hearing, Judge Glanville handed you a statute on perjury?
Can you say that again?
Do you recall testifying earlier that during the June 10th hearing, Judge Glanville handed you a copy of the perjury statute?
You can correct me if I'm wrong, but I thought the question was, did he hand it to me to give to Mr. Copeland?
Do you recall testifying that Judge Glanville handed you a copy of the perjury statute? Or better yet, let me do this. Did Judge Glanville give to you a copy of the perjury statute?
And said, hand this to Mr. Copeland? Yes.
Okay. And did Judge Glanville give to you a copy of the immunity statute?
And say, hand this to Mr. Copeland? Yes.
All right. And when you responded, let me back up. So do you not recall being asked in this courtroom today, did Judge Glanville ever give to Mr. Copeland anything?
I don't recall.
Oh man, we pull it. Going straight to Lil Woody handbook. Okay, so here's the difference between the two testimonies. Later on, they had Officer Long come in, and here's his testimony in case y'all missed it and didn't see it.
Miss Hilton specifically requested Miss Weaver not to take those communications down, correct?
I wouldn't say she directed Miss Hilton, Miss Weaver, but she did say she wanted to talk to Miss Bumpus before we went back on the record.
She made the request, Miss
Yes.
Hilton. Okay, and that was to remain off the record was requested by Miss Hilton and Miss Hilton alone.
Yes.
Can I get a little clarification there? So this is after the restroom break, right? Or whatever kind of break it was?
Yes, Judge.
Okay, and when Miss Hilton said, I want to speak off the record to Miss Bumpus for a minute, was Judge Glanville already in that room by then or not?
He had stepped in and then ended up stepping back out.
Okay, and so, all right.
Yeah.
Thank you.
Mm-hmm.
All right, so there's the two differences between those testimonies. You got one person's probably a little unsure, not sure about what happened. Then you have another person who's up here saying, this happened, this happened, this happened, this happened. We went here, they did this, they entered the room, they left, went to the bathroom break. I saw this person. Yeah, that actually happened, but what also happened was this. And Judge Whitaker is looking like she's buying the story of Officer Long there. Angel, this is live. We are live. So check this out. The court heard testimony concerning the matter on August 5th, 2024 from Ms. Bumpus and Fulton County District Attorney's Office Investigator Long, who was also present during part of the June 10th ex parte meeting. And that's what y'all just saw there. The court finds that an off-the-record conversation did occur at the behest of Hilton and with the consent of Ms. Bumpus. Judge Glanville was not present for the conversation. During the conversation, Hilton advised that if Lil Woody took the stand and either pled the fifth, having been told that such a plea was no longer viable due to the grant of immunity, or claimed that he killed Donovan Thomas, aka Big Nut, as Ms. Hilton maintained that the prosecution knew this to be demonstrably untrue, the prosecution would charge him with perjury. Also, during the conversation, Lil Woody made the statement, "You don't know what I did or didn't do." And Kayla mentioned this while she was on the stand. All right. During her testimony, Kayla Bumpus claimed that Lil Woody also said he knew more about the Infinity and someone not currently on the trial. But Kayla Bumpus also testified that Lil Woody's comment, "You don't know what I did or didn't do," was the extent of his comments regarding the killing of Donovan Thomas. Caleb Bumpus claimed distinct recollections of certain portions of the June 10th, 2024 events and acknowledged lesser recollection of other details. Dang, Caleb. They're going to call me a hater, though. She also acknowledged that there were times during the in-chambers meeting when she met and conversed privately with Lil Woody. Finally, Caleb Bumpus testified that once she, Hilton, and Lil Woody completed their off-the-record conversations and were rejoined by the predecessor judge, Judge Glanville, and his court reporter, that Miss Bumpus consciously endeavored to ensure that she immediately placed on the record everything about the substance of the off-the-record conversation. Yet Caleb Bumpus never had the record reflect that Lil Woody had allegedly just revealed to Miss Hilton that he had additional knowledge of the Infinity and a related connection to someone not currently charged. Long was present in the ex parte meeting from the time Miss Hilton and Lil Woody joined throughout the remainder of the meeting, including the off-the-record conversation. So he heard everything. Long testified that Lil Woody never said anything about an Infinity in Miss Hilton's presence and that he would have remembered such a comment because it would have been noteworthy. Okay, so again, this is why everybody was saying, oh, yeah, it went great. The test. No, it did not went. It did not went great. It did not go great. Okay. And Judge Whitaker is letting you know that when Caleb Bumpus got on the stand, she wasn't convincing enough. She couldn't remember things. She wasn't sure. She didn't know what happened. And then Officer Long got up there and he told exactly what happened. Even said some of the things she said in her stories that she could remember were true. But the fact that he said something about an Infinity weren't true. So I don't know, unless we get Woody or Miss Hilton on the stand, because they were the only two people factored in here and they say something different. The prosecution won this one because she said Long was present in the ex parte meeting from the time Hilton and Lil Woody joined throughout the remainder of the meeting, including for the off the record conversation. Long testified that Lil Woody never said anything about the Infinity in Hilton's presence and that he would have remembered such a comment because it would have been noteworthy. And Judge Whitaker believes Officer Long. In addition to the testimony of Caleb Bumpus and Officer Long, the court has considered Caleb Bumpus's knowledge as an attorney of her duties to her client and to the court, as well as a possibility that Caleb Bumpus, who admitted a lesser memory for certain portions of the ex parte meeting than others, may have confused her private conversations with Lil Woody and her conversations with Lil Woody that also included Miss Hilton. She said she was confused. She didn't know what happened. She didn't know if she was talking about when she was talking to Lil Woody or if she was talking about when she was talking to Woody and Miss Hilton at the same time. Not great, but we're moving past that. We're not going to beat a dead horse. I know we're going to have some people saying, I'll let it go. Okay, I'll let it go. Jeez. Regardless, the court credits the testimony of Long that Lil Woody did not, in the presence of the prosecution, either state or intimate, that he knew more about the Infinity and its connection to someone not currently on trial. So no additional Brady material was revealed in this consensual off-the-record meeting amongst the prosecution, Lil Woody, and Lil Woody's counsel. As the court finds that as there was no Brady violation with respect to the unreported portion of the June 10th, 2024 ex parte meeting, there is no relief to be provided. So ordered this the 8th day of August 2024, Judge Paige Reese Whitaker. So, yeah, getting on the stand for Kayla was tough. We watched it, we reviewed it live, and Officer Long, once he got onto the stand, he really rose and shone, and he was consistent with the story and pointed out some of the things that were said. Judge Whitaker took both into account. She said, it doesn't look like there's any Brady, especially since after the conversation took place, Kayla didn't say, hey, by the way, I want to put on the record that Woody just said he knows something about what happened with the Infinity and a couple of other things. So again, she said she was under a lot of pressure. It was a hard situation to be in. So maybe that's why she forgot. I don't know. Y'all have to let me know what you think about this one. Did Judge Whitaker make the right decision? Whose fault is it? Is it nobody's fault? Is it Kayla's fault? Is it Officer Long's fault? Is it Woody's fault for not speaking up again? We'll see. They're not going to like this one, y'all. They are not going to like that one. I know we've already probably, look, oh, here we go. Kayla was ambushed. I agree. Kayla was put in a terrible situation, and I mean, that's tough. But as an attorney, I mean, what are you going to do? It seems like that's part of the job. I don't know. I'm not an attorney. I'm just a guy talking on YouTube that likes music. So y'all tell me. I want to see what y'all are thinking. Amy's over there laughing. Oh, man. Let's see. Mixed Chick Samantha says, I only think Kayla was being a little petty. I don't think Kayla is lying. No, she just didn't remember. And that's why Judge Whitaker said that's why she's making the decision she's making, because she didn't remember. And not only did she not remember, but she also didn't put it on the record of what Lil Woody said. I'm sure she'll learn from this and moving forward. If that happens, not only will she learn from it, but there'll be other attorneys who are watching this, who are watching what happened. They'll be able to learn from it as well. Shout out to Mariana Boyd says, it's not Brady that Woody may have confessed or indicated. Oh, this is a question. It's not Brady that Woody may have confessed or indicated that he may know someone killed Donovan Thomas who hasn't been charged. It is, but it wasn't recorded. And you have someone who was there and who heard everything that was said that says it wasn't said. And then you have someone whose testimony was a little bit shaky, and Kayla Bumpus, and she says, well, I don't remember when this happened. This could have happened here. And actually that might have happened while I was talking to Woody. She says, I'm not sure. I don't recall. You have an issue there. And if it's not recorded by the court reporter, and Kayla, as soon as she went back into the chamber, said, hey, Judge, by the way, I was talking to Miss Hilton, and while I was talking with her, Woody said that he knows something about this Infinity. I think that might be something important that we need to put on the record. Then it would have been marked down. Then Judge Whitaker could have used that to say, all right, yeah, probably a Brady issue. So that's what's going on there. Amy says Kayla wasn't telling the truth about everything. Uh-oh. She says she doesn't fool me. She's played. She can't remember. She knew exactly what she was doing. That's tough. That's tough. That's tough. That's tough. Young says, with Kayla asking for press rights the day before she came across as, all right, I'm not gonna. Mixed Chick Samantha says, I was talking about on the stand. Kayla chose what she wanted to say, and again, it backfired in her face when Deputy Long got on the stand. Yep. It's tough. It was tough. Okay, let me double check and make sure I didn't miss any super chats. We are going for a long live stream today because I've got two more things I want to give to y'all. We've got, let me see, which one was this? Because we've got a lot of motions that came out here too. Shout out to Thugger Daily up in here. Oh yeah, this one, I remember this one. Oh man. This is another motion that's gonna hurt y'all's feelings. We'll talk about it here in a second. I don't think I missed any super chats. Let me double check here. All right, shout out to y'all. What does Amy say? Last thing, she says, I have a degree in forensic body language, and she definitely knew what she was doing. Okay, I'm not putting. Larry agrees with what most of us are saying. Everyone should have been there. I'm with you, Larry. I agree. Terry also says that was not a proper investigation. Considering Whitaker is speaking with Glanville, and has to report to Glenville still. And she only interviewed Kayla and the officer. Yeah, we need to hear from Hilton. We need to hear from Woody. Woody, you got to get on the stand, my guy. We got to get on the stand. Because why didn't Miss Hilton go up there? This is tough, man. And then we've got Floyd, the real deal Neil in here. Dropping the 2 bomb. Thank you for the super chat, man. He says, stream on, my brother. I'm going to try and get y'all out of here before 2:30. I don't think it's going to happen. Y'all know I'll be up here struggling. But these are really important. I want to make sure we get to these motions too. So I think we got everybody. Thank y'all for the love and support. Here we go. Y'all check this one out. So let me make sure I've got this here. Okay. Here we go. So back on, what is today? The 9th? So was this Tuesday? It was either Tuesday or Wednesday. I think it was Tuesday. Back on Tuesday, y'all know we got this additional motion from Brian Steele, aka Young Thug, to disqualify Lawyers Love and Hilton. And again, shout out to Thugger Daily for posting this one, because I wanted to reread this. Even though we reviewed the whole thing, I want to read a couple sections of this for y'all so you can remember exactly what Young Thug was saying and why he thinks ADA Love or Lawyers Love and Hilton should be removed. And then we're going to give you some information on what Judge Whitaker's ruling was on all of this whole thing. All right, so check this out. Young Thug, aka Jeffrey Williams, aka Brian Steele, and this is a letter to Judge Whitaker, says additional motion to disqualify Lawyers Love and Hilton comes now. Young Thug, by and through undersigned counsel, and hereby files this additional motion to disqualify Lawyers Love and Hilton in the above referenced case. In support of this motion, Young Thug shows as follows. Remember, he's innocent. Young Thug is innocent of all these crimes in the above referenced indictment. The Honorable Court denied Young Thug's original motion to disqualify Lawyers Love and Hilton on August 1st, based upon Young Thug's assertion that he intends to call Lawyers Love and Hilton as witnesses at trial. Okay. And now, why is he saying that he wants to do this? The enormity of violations of candor with the court, candor with the counsel, and the denial of ethical prosecution on this case are too much to permit Lawyers Love and Hilton to continue as lawyers in this litigation. Okay, I'm just going to read the first one because I think this was the most important one out of all that were mentioned. Recently, Lawyer Love filed a motion with this honorable court that undersigned counsel had a duty to provide work product. Lawyer Love knows that the same is untrue, and the cases that she cited in said motion did not support the propositions of law that she asserted in the motion. See motion to compel defendants' compliance with reciprocal discovery obligations and excludes any evidence intentionally withheld and not timely disclosed, filed on July 26, 2024. This was the 4th time Lawyer Love raised the same frivolous issue, attempting to hide Georgia law from this court. She was explained at the 3 prior hearings on the same exact issue. Okay, and then he shows a clip of the video. So this is basically what Young Thug was saying. He was going through and say, hey, these are all the reasons that they should be excluded. Most specifically is because I want to call them as witnesses, as we saw in his amended witness list. Now we're going to go over and we're going to hear what Judge Whitaker had to say about that motion that was filed by Young Thug. What did she say? And this was filed yesterday. An order denying defendant Young Thug's amended additional motion to disqualify Lawyers Love and Hilton. Oh, man. Here we go. Defendant Young Thug asserts that prosecuting attorneys Love and Hilton must be disqualified from the case because of an alleged ethical violation during the course of this trial in this case. As noted in the court's August 1st, 2024 order, a defendant seeking disqualification of prosecutors in a trial bears a heavy burden. This is important, of proving that such an extreme action is warranted. All right. And of course, we've got Lewis versus State that says it is the burden of the party seeking to disqualify counsel to prove the extraordinary remedy of disqualification is warranted. Defendants have submitted 8 examples of alleged misconduct and or ethical violations which have occurred in the approximately 8 months that the trial since opening statements has been ongoing. Certain of these items are also enumerated in defendant Stillwell's renewed motion for a fair trial and constitutional trial to extend that they are addressed and ruled upon here. Such rulings control, and this is in bold, the court reminds all counsel that every Georgia attorney is bound by our rules of professional conduct and owes a duty of candor to the court. These ethical and professional obligations should be scrupulatory. I can't see this, y'all. That's why I'm struggling with reading this. These ethical and professional obligations should be scrupulously honored, and prosecutors above all should endeavor to comport themselves so as to be above reproach on such matters. I'm gonna get glasses one of these days. The court understands that it has the authority to sanction counsel for violations of the rules of professional conduct that occur during and impact on the case before this court. The court declines the invitation at present. The court certainly does not condone the alleged actions of prosecutors Love and Hilton, which we really can't deny those, and nor is the court. The court has in weeks since assuming presiding duties made clear the expectations of all counsel, and the court admonishes counsel that any future failure to abide by the rules of professional conduct or lack of candor with the court may trigger the extreme sanction or of removal from this case. Yeah, whatever.
Stop the cap.
We heard this before. Upon consideration of defendant's motion and the applicable law, defendant's additional amended motion to disqualify prosecutors Love and Hilton in this trial is denied. Oh my gosh, come on. Sorry, I pressed the wrong button, y'all. I'm disappointed in Judge Whitaker. As you guys heard in videos we posted and clips we posted in the past from trial, the defense is really tired of Miss Love and Hilton specifically getting so much grace, getting break after break after break, saying, y'all, please don't talk while I'm talking. Hey, please make sure that you don't say this about the defense or about your fellow attorneys. Make sure that you're on time. Make sure that you file your motions on time. Make sure that you're not withholding evidence. And they're still just giving another break, saying, hey, I told them, Judge Whitaker saying, I told them that they need to get their act together, and I'm only going to warn them once. We'll see if that's the case, especially come Monday. And I know midweek next week is when Miss Love has her homework. Some of her homework is due. We'll see what happens, especially as this trial continues to go on. Let me know what y'all think. Was this warning enough by Judge Whitaker? Did she make the right decision not removing them from this trial? Y'all know how I feel about it. I want to hear what you think. Well, let's see what the comments are saying. We got one more thing. I'm going to get y'all up out of here. I do have glasses. Y'all want to see my glasses? I just don't wear them. I'm going to get contact. Marina says they give themselves presumptions that they acted proper, that their nefarious actions were harmless error, and conclude errors are not material. I think this is all constitutionally improper. It's bad. It's bad. It's just embarrassing. Like, they're allowed to do this time after time after time after time after time, and all they do is get a slap on the wrist, and the judge says, please don't talk while someone else is talking. Like, what? Why? It's crazy. Let's get into this last. Man, I might not be able to do this one. This is a good one too. It's a good one too. Amy said, I'm gonna get you a big magnifying glass. I'm gonna read it like this. Don't do that to me. Casper the Ghost says, rest in peace to ethics. Yeah, we don't care about ethics here in Fulton County. You'll get reprimanded, sure, but it's not a big deal. It's not a big deal. Don't worry about it. You know, if you want to withhold evidence, it's fine. You know, we're all good. Yeah, I don't get it. It's sad to see. Terry says, no, at this point. Oh, hold on a second. I lost my AirPods. Let me see. Y'all give me 1 second. I gotta fix my. I lost my sound. There we go. We should be back. Let me double check and make sure I didn't have someone else that called in. Okay, let's get to this last one, and then I promise I will get y'all up out of here. Shout out to iMommyMe98 says, at first I thought she was going to be a fair judge, but she proved that wrong. She proved that wrong too. She's just another one of them on the Fulton County that are corrupt too, all on the same team. Yeah. I'm a little disappointed in Judge Whitaker. I'm not going to lie. I know these are big deals, and I get that there has to be, what did she say? Or how did she say it? Extreme circumstances. But it's just, it's hard to watch them continue to get away with this. Continue to do whatever they want to when the defense has been above board most, if not all the time. Let me see. Couple more comments and then we'll get into it. Shout out to Uncle Paulie. He said, this ruling sounds like Glanville wrote it. Oh my gosh. Angel says, Judge Whitaker is being smart. She wants the prosecutors to look incompetent. Yeah, we'll see. We'll have to see what happens come Monday. Because Monday, it's going to be big. Because after Monday, even though there are a few motions she still hasn't ruled on yet, it's really going to be in her hands to decide how this case is going to go moving forward. Because if the jury says we're good, I don't remember anything Woody said other than, what you mean? If, you know, we get there on Monday and Woody's like, yeah, I'm going to testify and say whatever I need to say and then get up out of here. It's going to be on Judge Whitaker to keep things moving forward. But anyway, let's go ahead and get into this last thing. I appreciate y'all commenting, man. Thank you to everybody who liked the video. We got over 500 likes. Shout out to y'all. Casper's, oh man, taking one of my quotes. Are you taking my quotes, Casper? Said my love for Judge Whitaker is fading quickly. I said that exact same thing earlier on Cat's stream. That's funny. Amy says maybe she denied it because she's already planned on going with the mistrial. Maybe. I can't read her anymore. I feel like I don't even know her. I don't even know her anymore. All right, check this out. So Judge Whitaker talked about in her denial of that last motion we looked into that was trying to disqualify lawyers Love and Hilton, that Mr. Stillwell actually had a motion that he wanted a fair and constitutional trial. Now we're going to see what her ruling was on that, and we're going to read through it and see some of the reasoning behind why she feels that way. All right. Shannon Stillwell, aka SB, aka Mr. Max Shart. And this is from Judge Whitaker. She says an order on defendant Stillwell's renewed motion for a fair and constitutional trial. All right, y'all check this out. Defendant Stillwell raises numerous assertions of error, impropriety, prosecutorial misconduct, and judicial partiality. Y'all see, I got it that time. I've been practicing. Which he asserts have resulted in a denial of his constitutional right to due process and fair trial. The pertinent determination is whether such events, if they occurred as alleged, warrant a mistrial with prejudice, dismissal of the indictment with prejudice, which would have the same effect, or disqualification of the prosecutors. Claim 1. We know the claims, but we'll read through them pretty quickly. A plague of discovery violations, missing police reports, and Brady violations. Discovery is being addressed. We went through that this week. The court has ordered the state to timely produce all discovery and undertake a concerted effort to secure and provide all police reports, including asking current APD personnel with specificity to search for and produce reports on this case. And I think that's due next or midweek is what Judge Whitaker said. Okay. And then as recently as the court proceedings on Friday, August 1st, the court confirmed that the state's understanding that Brady obligations include the disclosure of material impeachment items and reminded the state of its continuing obligations under Brady. All right. Claim 2, prosecutorial failure to follow the court's orders, making of specious allegations against defense counsel and counsel for a witness, and lack of candor to the court. We all read from the transcripts on June 7th that they were talking some mash. Any past failure of the prosecutors to follow orders of the court is a matter of record. Aside from the broad assertion of a denial of defendants' rights to due process and a fair trial, no specifics establishing this assertion and no claim of refuting legal error is alleged. Okay, so it looks like she's going to move on from that one. So we'll keep it going too. Basically, she's saying the past is the past. Any specious allegations against defense counsel, counsel for a witness, or a lack of candor with the court at minimum is extremely unfortunate. She said, I'm sorry y'all got your feelings hurt. Claim 3, improper evidentiary rulings by Judge Glanville. A defendant is entitled to a fair trial, but not a perfect one, for there are no perfect trials. The people's versus the state. Evidentiary error, which involves mistakes under Georgia's procedural rules and evidence law rather than any constitutional violation, can be addressed in post-trial review. Okay, so we just got to wait. Lord have mercy. Claim number 4, mistreatment of defendants and their counsel by Judge Glanville. Aside from a blatant assertion, the motion does not detail any alleged mistreatment of defendants. We got whole YouTube videos we could point to if you need to see them, Judge Whitaker. Come on now. The alleged mistreatment of the defense counsel detailed in paragraph 9, A, E, and H is not alleged to have occurred in front of a jury and even accepted at face value, would not raise the level of violation of defendant's due process or fair trial rights. So he didn't do it in front of the jury, even though he called Brian Steele unprepared and unprofessional. Still not enough to be an issue is what she's saying. Claim 5, improprieties in an illegality, of the June 7, 2024 ex parte conference. In open court on June 7, 2024, the prosecution requested an ex parte conference with the court. June 7th, 2024 transcript, page 94. The defense was therefore on notice of this request. The defense also knew that the request was not to secure immunity for Lil Woody, as the immunity order had been signed in open court earlier in the same day's proceedings. Even assuming the right to be present for this June 7, 2024 conference, no one on the defense team objected to the request or sought more information about, thereby waiving any right to be present for that conference, which I don't remember seeing them saying that they should have been present, but I could be wrong. I could have missed something. As for the topic of the ex parte conference, defendant assigns nefarious intent to prosecutors Love and Hilton's representations about their interactions with Lil Woody's main counsel, John Melnick. The court at this point declines the invitation to view their representations, but refers the prosecutors to its footnote 1 herein. Yeah, but they were also saying some stuff about Kayla too. So we'll just go down through these. Claim 6, illegality of the June 10th, 2024 ex parte meeting. We know what that was about. And then we had, oh man, he tells the whole story here. And we already know pretty much why Judge Whitaker said the ex parte meeting wasn't a big deal. And she basically is reviewing that and going through that again. So let's go back to this last one. The defense knows of this statement and indeed of all what occurred during the June 10th, 2024 ex parte meeting. The contents of the meeting were ultimately revealed during the course of trial and in time for defense to utilize it. So failure to produce such or suppression of this information does not technically amount to a Brady violation. And they're saying Kayla didn't really show or give her anything that would say, yeah, this is information that the defense should have been made aware of. But the fact that a violation of a defendant counsel's rights has been asserted does not, under these circumstances, provide cause for celebration. All right. What it does provide is cause for sober reflection and examination of processes, or processes if you prefer, procedures and approaches that permitted this likely inadvertent but nonetheless serious Brady lapse to occur. Defendant seeks as a sanction the disqualification of the state's two lead prosecutors. Because this does not appear to the court to have been a purposeful violation. What? But rather a negligent overlooking of the impeachment value of Lil Woody's in-chamber statement, the court does not order their disqualification. What is going on, man? Judge Whitaker, what happened? So because, how is it not purposeful? Everything about this was purposeful. And you even had Judge Glanville over there as a hype man, or Miss Hilton over there as a hype man, as Glanville's explaining to Woody what was going to happen to him, what everything meant. She would say, yeah, that part. Tell him. They're getting so much grace. It's absolutely insane. At the same time, the court is cognizant that defendant's liberty, as well as the liberty of his co-defendants at this trial, is at stake. That the prosecutors involved are knowledgeable and experienced, and that this is not the first allegation of prosecutorial misconduct in this case. So if you know that, then get him up out of here. The court therefore orders, as a remedial measure, that the entire prosecution team working this trial submit to training on Brady and other professional obligations of a prosecutor. I don't understand these motions. How is the judge going to say they did all of this and messed it up and it wasn't a purposeful violation, it was just negligence? So what she's going to do is she's going to send them to training. Wow. Thank you, Judge Whitaker. Seems to be fair. Prosecuting attorneys, Council of Georgia. Oh, I'm sorry. Let me read that again. The training will consist of a video replay of training on this topics previously presented by the Prosecuting Attorneys Council of Georgia. I'm sure it'll make a difference. The court will provide the video and the viewing will occur under the direction of the court. So ordered, this the 8th day of July, or the 8th day of August 2024. So Judge Whitaker, they're basically going to the principal's office and they got to watch a video. They have to stay after class and watch a training on Brady. Wow. So because of all of that, this motion is denied. Y'all have to let me know what you think in the comments. Are we losing Judge Whitaker? I'm kind of sad. I thought she was going to be solid. Maybe she still is. Maybe she's just doing her job, and we'll see what's going to happen in the next couple of days. Y'all let me know if she made the right decision. All right. I appreciate y'all, man. Shout out to everybody who's showing love and support. I can't believe y'all have been here for almost 3 hours. Crazy. I love it. Amy says she likes the principal's office.
Hey, yo.
Shout out to Amy, the sponsor of today's show. Thank you to everybody else who sent support in as well. Shout out to Jaina over there. We also had Mr. Floyd, the real deal Neil. We had Amy gifting 15 memberships and dropping the 2, the 5, the 149 2 times, and the 5 bomb over there. I appreciate y'all supporting. We are going to be back on Monday. Y'all know Monday is going to be crazy. We've got so many things that are going to happen, could possibly happen. So make sure if you haven't yet, subscribe to the channel, hit the notification bell, because we're going to be dropping some videos over the weekend as well, as y'all well know. So you don't want to miss out on any of those videos. We will be live. I wonder if they're going to live stream when Judge Whitaker's talking to the attorneys. Probably not. So we'll probably be live here Monday morning at 8:45. I hope y'all have a great weekend. If y'all love music, if you want to check out some up and coming independent artists, make sure you tune into the Song of the Night tonight, right here on the ClassE Beats YouTube channel at 8 p.m. Eastern Standard Time. I appreciate y'all. I hope you have a great weekend. And you know what to do. Keep growing, keep pushing, keep it classy. We gone. Peace. Appreciate y'all.
You know.
We're real strong people. We can do anything. We can't be worried about what they say. My brother, my sister, just believe in yourself. Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself. Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself.
Since everything starts with self, let me hold this mirror up and take a look at myself. Before I judge you, I gotta check myself. And I come to find out that that's good for my health, right? Change your mind and watch the whole body follow. So you won't hear me talking about I'm hitting you with hollows. I can't do it, got plans for tomorrow. And I ain't trying to bring my seeds no type of sorrow. Wait, cause fake rappers do fake-ish. I mean, most the basic get replaced quick. I'll never sacrifice my soul. Truth is, so I might never get 1 million records sold. But that's cool, cause I'm good with the creator. He nurtured my thoughts, so I present you with verbal flavor. You never listen to what no haters say. We pray for them, but we gon' move it this way. We moving forward, y'all.
We can do anything. We can't be worried about what they say. My brother, my sister, just believe in yourself. Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself. Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself.
I feel like George Floyd, yo, I can't breathe. It's hard.